Request everyone to please settle down as we are going to start the session. Good morning, everyone. So we are going to start the fourth technical session today. After a long day yesterday, we have a learned speaker, Mr. G. Shivdas, Senior Advocate. Would request him to please join the dais. I will also request Past President, Mr. P.C. Joshi, sir, to please join the dais as the chairman of the session. A big round of applause. So please. Would request Ankit Bothra to also join the session. Mr. Shivdas is a senior advocate designated by the Karnataka High Court in 2018 with more than 31 years of standing at the bar. He is well respected at various legal forums, primarily appearing in the High Courts of Karnataka, Andhra Pradesh, Telangana, Kerala, Kolkata, New Delhi, and the Supreme Court of India. He is also highly regarded in various quasi-judicial forums and arbitral tribunals. His specialization include central excise, customs, EXIM policy, and WTO laws. Sir has been consistently ranked in the top 10 indirect tax practitioners in India. We welcome sir to the platform of AIFTP East Zone, and I would request our Smith Saurabh sir to please come and felicitate sir on behalf of the committee. Thank you, sir. So without further ado, I would hand over the proceedings to the chairman of the session, Shri P.C. Joshi, sir.
I don't think it is necessary also. I can speak loudly. Thank you. Well, you have heard two taxes. One is direct, another is indirect. That reminds me what you always experience at home. When you give to your wife on the first of the month, it's a direct tax law. And when she picks up during the month without knowing you, without your knowing, that is indirect tax. So, we have today a learned speaker, a well-known person, a much demanded person, knowledgeable person, an advocate who will speak on indirect taxes. So, he will let you know what are the methods by which you can avoid indirect taxes at home also. So, over to Mr. Shivdas. All the best. Well, as far as I am concerned, I was not knowing that I was to preside over today. When I was sitting in the lobby, Mr. Vivek came in to me, told me that you have to preside. I said, I am not prepared. It doesn't require. I will share my knowledge from my own God-given computer. I don't have computer. God-given computer is with me. Thank you. Yes, go ahead.
A very good morning to all of you. It's very nice to be in the midst of seasoned tax practitioners, a combination of chartered accountants and lawyers. I've always believed that a combination of a person who is a chartered accountant and a lawyer is a deadly combination.
এটাই তো অন করলাম, কোথায় অন করেছি, এটাই তো অন
And if
করলাম।
you have seasoned practitioners like all of you, I mean, the way I have been introduced by Venkat in the morning, all of you have reasonably about maybe 40 years, 50 years of practice in the field. So, what we would do in this session, Namaskar, sir. What we would do in this session is, in fact, this is the no, in fact, when Venkat told me that we need to do a session on GST today, I was thinking, how do I do it? Because all of you would have been seeing these provisions on a daily basis. So for me to explain the provisions to you may be one, unnecessary, and two, I think all of you are more seasoned than me in all this. So what I thought was that I would pick maybe about 6 issues with which I am maybe struggling on a daily basis, and then give you my perspective on those 6 issues, so that you can also contribute to your views on those 6 issues. I thought that would be a better way to do it. And these 6 issues are among a number of issues that are coming up for consideration of the courts, etc. So I thought that would be a better way to do it. Sir, you don't mind? Oh, sorry. Because I was only worried that you'll have to see it. Okay.
Fine, go ahead.
Sir, you have a collar mic, is there? So people can come to the front. People can come to the front rather than sitting in the...
Take your seat immediately. Let us not disturb the speaker. This is the benefit of technology.
We start those, okay. So we'll pick for about 6 issues. We will see what the issues are, and then I'll give you my perspective on that issue. All of you also can look at it, and what you can also tell me, that would be a better way to do it. So what we would do is look at some of the emerging controversies and how do we navigate disputes that have come in those controversies. Now this is one issue in GST regarding valuation between related parties or valuation between distinct persons. Now the provision is relatively clear. The value of supply of goods shall be the transaction value which is actually paid or payable for the goods or services where the supplier and receiver are not related persons. This is a normal transaction value which all of us have. This is a carry forward from the pre-GST regime also. what we had in excise, what we had in customs, is now carried forward to GST. Now, if you look at the GST law as distinct from the earlier one, you have Rule 28 that talks about value when transactions happen between related persons. Now, if you look at the last proviso, our problem starts there. Provided that where the recipient is eligible for full input tax credit, the value declared in the invoice shall be deemed to be the open market value of the goods or services. Right, sir? What is the whole purpose of this proviso? It is to say that when transactions happen between related persons, and if the recipient is entitled for the full input tax credit, then accept the value that is declared in the invoice. That's the whole logic. Because whether it is 100 rupees or 120 rupees or 150 rupees, full input tax credit is available to the recipient. So don't disturb the transaction value for a reason that the value may not be right. And this proviso is because of the effect of decisions in the pre-GST regime. All of you are aware, pre-GST regime, the courts always took a view that if somebody is entitled to full input tax credit, why are you getting into these disputes regarding valuation? So 10 rupees on 100 rupees or 10 rupees on 50 rupees or 10 rupees on 200 rupees, the full input credit is available to the recipient. Therefore, they said that where the recipient is eligible for full input tax credit, the value declared in the invoice shall be deemed to be the open market value of the goods or services. Right, sir? Now, there is also a definition of what is open market value. Because all of you would have seen all this in the GST law. Yes, sir, please. I was only worried you should not strain by seeing it. This is much bigger.
I am not able to read.
Yes. It's okay. You can see it. You are young. There's no problem. Right, sir. Now, the rule also says how you go by, you can put this light off, sir. You can put these lights off so that this is visible. It will be too much of a, it's visible, sir? Okay. Now, open market value or value of goods or services of like kind or quality, value of supply based on cost, or value of supply using reasonable means consistent with the principles and general provisions of GST law. There is also a definition of an open market value. Open market value means the full value in money payable by a person where it is not related. These are the provisions. Okay, sir. Now, where does the problem start? All of you would be aware about this circular also.
Can we not start with section itself, section 15?
That's how I started, sir. My first thing was with section. I'll go back to the section again, there's no problem. The first 2-3 slides was with the section. This was a section, sir. The value of supply of goods or services shall be the transaction value, which is the price actually paid or payable for the said supply of goods. Where the supplier and the recipient are not related, price is a sole consideration. That's a normal transaction value definition. Now, what they do is, when it happens between related persons, today we are having a problem where transactions happen between related persons. And the definition of related person is very, very wide in GST. They have borrowed the definition essentially from the customs law. The excise law was slightly restricted in terms of related person. Customs law was much, much wider. So that definition has been practically borrowed in the GST law. Right, sir? Now the problem happens when you are disputing the transactions between related persons. So how do you decide the value? Now that is where this proviso has been introduced in the rules. This proviso is there only in the GST law. It was not there in the pre-GST law. But the effect of it was because of certain decisions by the courts. Now what does the proviso say? Recipient is eligible for full input tax credit. The value declared in the invoice shall be deemed to be the open market value of the goods or services. Because if somebody is taking credit, accept the value. Don't unnecessarily disturb it. Okay, sir? So the proviso is a well-intended provision by the government. This proviso is a well-intended provision by the government. Now, what is the definition of how do you derive the value, etc., is also provided in the rules. So you go by the open market value, or you go by services of like kind or quality, or based on cost, or any other reasonable method. That's a sequence in which you can proceed. And they have defined what is called an open market value, where you are selling to somebody who is not related to you. That is taken to be the open market value. Now this is where the issue has started, sir. And the circular that is issued also has been issued to put an end to a lot of litigations. Well-intended circular. Now this is where the head office provides certain services to the branch office. Pre-GST regime, transactions between the head office and the branch office was not taxable because it was a centralized tax. Now post-GST, since a head office and a branch office in a different state should have different registrations, they are considered as distinct persons. So they are considered as distinct persons. A service provided by the head office to the branch office will be considered as a supply of service by the head office to the branch office. Therefore, it is taxable. We will proceed on the basis that it is taxable. We will not get into the larger question of whether they can tax it, etc. or not. We will not get into all that. Now, this circular that has been issued, 199, it's a very nicely written circular. In respect of internally generated services, there may be cases where the head office is providing certain services to the branch office for which full input tax credit is available to the concerned branch offices. However, head office may not be issuing tax invoice to the concerned branch office with respect to such services, or the head office may not be including the cost of a particular component such as salary cost of employees involved in providing such services while issuing tax invoice to the branch office. So, certain services will be provided by the head office. Normally, in other than this GST law, in any other law, no head office will issue an invoice to a branch office. Service may be provided, may not be provided. You may not have inclusion of certain cost components. For example, you will have the director sitting, the financial director sitting, the managing director sitting. You may attribute a cost of it to the branch, you may not attribute a cost of it to the branch. So this says whether the head office is mandatorily required to issue invoice to the branch office under section 31 of the CGST for such internally generated invoices, and whether the cost of all components including salary cost of head office has to be included in the computation value. So 2-3 questions were raised. Should the head office issue an invoice, one, for internally generated invoices? Two, should they include all the cost components? If they don't include, what happens? This is the query that is raised. See the way they have answered it, sir. Second paragraph is what is important on the right hand side. Accordingly, in cases where full input tax credit is available to a branch office, the value declared on the invoice by the head office shall be deemed to be the open market value, irrespective of the fact whether the cost of any particular component of such service has been included or not included. Correct, sir? Then, further, in such cases where full input tax credit is available to the recipient, if the head office has not issued a tax invoice to the branch office in respect of any particular services being rendered by the head office, the value of such services may be declared to be nil. So, two things they clarified. One, they said that whatever value is declared by the head office, please accept it. Whether they include all the components or not, please accept it. If they don't issue a tax invoice, take the value to be nil. Take the value to be nil. The logic is, even if you issue a tax invoice, the branch office will take credit. Correct, sir? Till here there is no problem. Till here there is no difficulty. Now we have a situation where even for services provided by the foreign branch office or a foreign head office to a branch office in India, what will happen? They applied the same logic and said, since the Indian entity also will take the entire credit, therefore please accept the value declared in the import invoice. That's a similar clarification issued in circular 210. No difficulty here also. Now the problem comes when you get credit. Right, sir? Because the proviso says full input tax credit is available, then you should accept the invoice. Now, what do we mean by full input tax credit available? And I'll tell you why. The problem which I faced is what I thought I'll share with you. Suppose there is a company that provides IT services, information technology services. You have a foreign entity that provides IT services to the Indian entity. So the foreign entity will charge the Indian entity. The Indian entity will pay the foreign entity, pay tax on a reverse charge basis and take full input tax credit. No issues so far. Correct, sir? Please tell me if I am going slightly fast. Stop me if you think I am not clear at any point of time. So, when the foreign entity charges the Indian entity will pay to the foreign entity, pay tax on a reverse charge mechanism and take full input tax credit. No issue so far. But suppose the Indian entity has some 0.1% of exempted sales. Suppose the foreign Indian entity has completely an unrelated supply of exempted sales. For example, some agricultural products are there in that Indian entity's premises. It sells them. That will be exempted. Now, can the department say that you are having a 0.1% of exempted sales and therefore the proviso will not apply to you. You will not be entitled for the full input tax credit. Therefore, since you will have to proportion it, therefore we can disturb the value at which you are receiving services. Can they say that? Yes, sir. Process. Therefore, if you have certain transactions which are not so significant, a wastage that happens, an exempted goods sales that happens, so can the department say that since you are not entitled for the full input tax credit, there are certain exempted sales that are happening, therefore that proviso will not come to your rescue, the proviso to Rule 28 will not come to your rescue, therefore we will look at your transaction value.
Evaporation during transit.
So there are practical cases that can happen. Or should we say that as far as the input services are concerned, that are completely used for an output service on which tax is payable. So in that stream of input services, full input tax credit is available. You should not look at the small insignificant quantity of exempted goods. We will get the benefit of the proviso. In my view, that is the correct approach. You should look at the term eligible for full ITC to be interpreted on transaction basis or in relation to the recipient as a whole. According to us, it should be with reference to the transaction basis. That's the first point. Two, all of you who have been practicing excise pre-GST would recall, there used to be a lot of decisions on very insignificant quantity of exempted sales, exempted goods or services. We used to have that concept of Rule 6, Rule 57cc and all that, where you have to reverse 8% or you have to pay 10%. Courts used to say that look at the insignificant quantity, ignore that for the purpose of the full input tax credit. Therefore, can we apply that to say, you have what is called a theory of de minimis value. De minimis is a certain percentage which is considered as to be the limit for the purpose of any transaction. So 2%, 1% or whatever it is. So can we argue that there has to be a de minimis value of exempt sales, or can an unrelated exempt supply involving no common inputs or common services render the assessee ineligible to claim the benefit? So this is one issue that is coming up in a much larger way with companies where the transactions value are entitled for full input tax credit, but some small insignificant quantum of exempted sales are there. The department is proceeding to say that you will not be entitled for the benefit of the proviso to Rule 28. So, outlook of the department. So, we have been trying to argue that ignore that 1% or 2% of exempt sales, look at it from transactions perspective, we will get the benefit of the proviso, and therefore the transaction value should be accepted. This is one issue that is coming up everywhere.
Now, after demonized value, what is the definition of demonized value?
Sir, what happens is we have to take shelter under the other laws that are there. For example, if you look at the anti-dumping duties, anti-dumping duty under the customs law, etc., they always have this concept of de minimis value.
No, see, the consider them as well practicing in sales tax. So please elucidate properly as far as the custom is concerned.
Okay.
Because there are many of the people will not know what is the custom.
Okay, sir, no problems.
Please.
I'll do that. Now, this concept of de minimis, I'll come back to the earlier slide. This concept of de minimis value means a certain percentage that is prescribed by law, by which it is said that anything beyond this percentage is what the government will look at. Anything below that percentage, the government will ignore. That is normally applied in cases where the goods are subjected to what is called as anti-dumping duties. Now, some of you would have...
What about the goods we get evaporated
Yes, sir.
because of the climatic condition?
Or see, what happens of goods that are evaporated or that are lost in processing or that are lost because of storage? There could be any number of reasons why it is lost. Now, therefore, the customs, the anti-dumping law recognizes that beyond 2% is what the government will look at. Anything less than 2%, the government will ignore,
Irrespective of the nature of the goods?
irrespective of the nature of the goods.
Oh, I see.
Therefore, we have to draw our support from the allied laws which have this de minimis concept. One is the anti-dumping duty law, which is in terms of the customs law being looked at to say that yes, look at this 2% percentages. There are certain other, for example, the Standard Weights and Measures Act have certain provisions. So many other provisions are there which will say that look at a minimum percentage. The logic of de minimis is look at a minimum percentage, give them the benefit of it. Percentage to be ignored. So, if you look at 2%, then you can say that yes, my exempted sales is only 2%, less than 2%, ignore it. Look at it from a transaction perspective. Apply the provisions that are available to us in terms of the other laws and apply it for GST law. Why I am suggesting this is GST as a jurisprudence is evolving over these periods. It has settled maybe in the last 2 years or so, having been introduced in 2017. It has got settled maybe in 2023 or 24. 20 to 22 was lost in COVID. So not much of development could be there. But up to 24, after 24 it's getting to settled. Therefore, the jurisprudence in GST has to now start getting established. So it is time for all of us to help contribute in this jurisprudence of GST law.
And create many kinds of controversies.
That the department will do it, sir. Creating controversies, the revenue will do it. But as far as because at the end of the day, companies who come to us look for solutions to their problems. Because there are certain problems which are one-time problems, there are certain problems that are recurring problems. So we need to give solutions to them for their recurring problems. So this is one issue that is coming up in a number of companies. I'm sure all of you also would have experienced such problems in your practice. Yes, please.
My view is that,
Yes, sir.
this de minimis value, being a question of fact,
Correct, sir.
may be dealt with in a better way, situation to situation, practical circumstances, by the GSTAT.
Correct.
Which is in the formative way, maybe 2-3 months
There
we will
are,
be.
there are two ways it can be done, sir. One is the government itself can prescribe a percentage to be considered as de minimis, because that can solve lot of problems. Yes, because the moment you move it to a determination on a factual basis, you are leaving it to the wisdom of the tribunals at different states to have different yardsticks for same product at different levels.
It will open the floodgate.
It can. See, what happens is today, unlike your pre-GST regime, you leave the VAT tribunals, but otherwise the central tract tribunals were practically about maximum 6 or 7 or 10. But in G-Stat, you are going to look at about 31 tribunals. So we should not land up in a situation of having 31 decisions on the same issue. That could be better avoided by the government prescribing a particular percentage towards the de minimis theory. And I am told,
Certainty should be established.
yes, and I am told, I mean, this is what we have been hearing from people, that the government is seriously considering fixing this de minimis percentage for the exempted turnover. That's the call of the trade, that's the request of the trade. So that I think is being done. Anyway, if it comes, that will help all of us. So this is the first issue I thought yes. So this is the first issue that was there. Now I will come to the second issue which I face. This is as a result of the recent rate reduction notification, where the rate is reduced from, if you look at the first one, इसमें highlighter नहीं है क्या? There's no, इसमें highlighter नहीं है? Okay, yeah, thank you. Thank you. Now, if you look at this notification, this is as a result of this recent rate reduction by the government. For beauty and physical well-being services falls under 2.5. I have taken one example. There are any number of notifications where this reduction has happened. So you are entitled to pay 5%, 2.5% is one tax, another 2.5% will be another tax, CGST and SGST. So you will pay 5%. Other services are 18%. Now when you are looking at 5%, see what is the condition. Provided that credit of input tax charged used in supplying the service has not been taken. The logic is you will pay 5%, don't take input tax credit. Because they don't want you to take input tax credit and discharge a lower rate of tax. This is a condition that is there. Then somebody asked me, do I have an option of not paying 5%? I will pay 18%, but I want to take input tax credit. The notification says you can pay 2.5 into 2, 5%. However, the condition is that the credit of input tax charged should not be taken. I don't want to pay this 5%, I want to pay 19%. Can I take the input tax credit? Where is the law that says that I should opt for this 5%, thereby not taking the input tax credit?
Because this 180 are different services.
Yes, sir, two different services.
So as far as one is concerned, you have only one option.
Yes. What happens? Yes. Suppose I don't want to have this notification. I want to charge 18%. Why? what is the law to say that I should opt for this serial number? I don't want to pay 5%, I want to pay 18% because I have a huge input tax credit. I want to utilize input tax credit and pay 18%. Now, there is a provision that is introduced, and you look at this proviso also before I take you to the provision. For the removal of the doubt, it is hereby clarified that supplies covered by item number 1 in column 3 shall attract central tax prescribed against them in column number 4, subject to conditions specified by in column number 5, which is a mandatory rate and shall not be levied at the rate specified under this item. So the proviso says, for serial number 1, go by 2.5, go by the condition, don't go by 9. Correct, sir? This is the notification. Suppose I don't want to avail the notification. You can't force me to avail a notification. I don't want to avail the notification. Is it open to me to do it? Does it make commercial sense? It's a different point. I'll tell you why. This is section 11 under the GST Act. You see how it is worded. A lot of thought has gone into each of the provisions under the GST law. Therefore, we need to appreciate the intention behind each of the provisions. See what it says. Where the government is satisfied that it is necessary in the public interest to do so, it may, on the recommendations of the council, exempt generally either absolutely or subject to such conditions. Absolute is without any condition, or subject to such conditions. You should not take credit is one such condition.
Yeah, but it is subject to recommendation of the council.
Yes, sir. All these are made on the recommendations of the council. That there is no dispute.
Yeah.
All these notifications are made on the recommendations of the council. Now look at the explanation, sir. For the purpose of this section, where an exemption in respect of any goods or services or both has been granted absolutely, the registered person supplying such goods or services or both shall not collect the tax in excess of the effective rate on such supply of goods or services or both. So the proviso says, once I give a notification, once I prescribe a rate, then whatever may be the situation, you should not collect tax in excess of that 5%.
Suppose it is collected.
Then,
Is there forfeiture?
yes, sir. There is a forfeiture provision in GST law, like we used to have in the sales tax law.
Yeah.
There is a provision in the GST law also. So now see the position. The earlier notification says you should pay only 5%. I should not take the credit, so I cannot utilize the credit. And the section says I should not collect more than 5%. So, does it mean that I cannot choose to pay 18% in a case where the notification says only 5%? If it is only 5%, then I cannot take credit also. So what happens to this credit? Is this credit a cost to the companies?
Is it
Because-
not a restriction of trade?
Yes, sir. Therefore, how do we take it forward? Suppose companies come to us, because these reductions have happened, though their time has been given to the industry to react. They gave about 10 or 12 days time for the reduction in the rates of tax. But the accumulation as credit for a lot of companies have happened over a period of time. So once there is a restriction over a period of time, if you ask them to pay tax at a lower rate from a particular date, and also say that you cannot collect the tax, what happens to the input tax credit that is in stock or that is in their accounts? What happens to that? That's a serious problem which the companies will face. Because you can't pay more than 5%, you cannot take credit, you cannot collect the tax also.
Is it not unreasonable restriction
One. But the
of trade, fundamental right?
The problem, sir, from the government side is they have rather told that some conversations there, I think it's disturbing people here. That's what is.
Please put off your mobile, or if you want to talk urgently, please go out of the hall. Please do not disturb the speaker.
Now, therefore, that's the second issue which the government, which the industry is facing, that we are supposed to pay 5%, we cannot collect anything more than 5%, we cannot choose to pay 18% and utilize the credit, therefore, the credit becomes a cost. What do I do with it? Right? How is the government going to react to it? We don't know. I am told that the government is considering situations or circumstances under which they can give a refund of the excess credit that is available. But as on today, that will be a cost to a number of companies. Whether it will be open for the companies to challenge in the courts that they should have the freedom to not to pay tax at 5%, but to pay tax at 18% is something which the courts will have to consider.
Arbitrary restriction of
Possible.
trade.
Possible. Right, sir? So that's the second issue. Now let's look at the third issue. Now, all of you are aware that for a number of products, there used to be a levy of GST plus compensation cess. For example, motor vehicles. Motor vehicles used to be taxed at 12%, especially the luxury motor vehicles. 28% as tax and about 12% as compensation cess, roughly around 40%. So many other products are also there. Aerated water was there. So some of these products have a combination of GST and cess. Now, if you had seen the provisions relating to cess under the Compensation Cess Act, if on your inputs cess is payable and if on your output cess is payable, you can take credit of the input cess and utilize it for payment of your output cess. You cannot utilize input credit of cess for payment of GST. That's not possible. That restriction is there. So input cess for output cess. Input cess not for output GST. So till now, till this reduction in the rate happened, if you have a input where input GST is there and input cess is there, and if you have an output product where output GST is there and output cess is there, you can utilize the input tax credit for payment of output GST. You can utilize input cess for payment of output cess. That's the position till this recent rate reduction. Now, what happened in the recent rate reduction? Recent rate reduction said the compensation cess that was levied on these products is now reduced to nil. There is no compensation cess today for the motor vehicles.
Is there any instance where cess is on input and on output there is no cess?
Today's motor vehicle from this notification is like this. So you have a cess on the input, you don't have a cess on the output. But you have an GST on the input, you have a GST on the output. What they have done is, they have merged the GST rate and the cess rate. So it has become 40% as an output GST rate. So I'll repeat this once again, sir. Earlier, let us assume 18% input GST, 12% output GST. 10% input cess, 10% output cess. So your input cess, input GST you can utilize for making payment of your output GST. Your input cess you can utilize for payment of your output cess. What they have done today, they have merged the output GST and the output cess. So it becomes one rate as output tax, output GST. There is no output cess today. Now, if you have to clear your supply or goods tomorrow or from that day whenever the notification has happened, you have a huge credit of cess, you don't have a cess payable. You have your input GST, you can utilize it for payment of your output GST, no difficulty. What will you do with your input cess credit? You have already paid for it, it is in your books of accounts. Some companies, I am told, have about 200 crores, 300 crores of input cess lying in their books of accounts. What will you do? Can you claim refund? You cannot utilize it. If you cannot claim refund, how do you? It is after all an amount you have paid for and got it. So what do you do for the refund of the cess? That's a big problem which a number of companies are now facing. I looked at it from in a different perspective. That's why I looked at the provisions and I thought I will also share it with all of you. All of you also can have a look at it. Maybe if that appeals to all of you, maybe all of you can take it forward. No, sir. This is a tax I have paid when I have got the inputs. So that is in my credit account. But I cannot utilize that credit cess for payment of any output cess because there is no output cess. So what do I do with the input cess? It is in my books of accounts. I can't utilize it. I should get a refund. Ideally, I should get a refund.
It's a case of inverter.
Now, we will go to that. That's what we should look at now.
Yeah.
That's what we should look at now. Now, yes, sir.
And also in the balance sheet, the sales assets is also be there. That is the problem of the company.
Absolutely.
That is the problem that the assets is in my hand, but no use of that asset.
Exactly.
That is the problem of the company balance sheet also.
It becomes more like a dead asset.
Debtors,
Dead asset in your books of accounts.
books of accounts.
So what do you do with that? Okay. Now this is a problem for essentially companies who deal with coal, companies who deal with motor vehicles, companies who deal with aerated waters, essentially, because that is where the cess has been reduced. This is the notification that has been issued, 17/9/2025, whereby the compensation cess on aerated waters, coal, motor vehicles shall be nil with effect from 22/9/25. So from 22/9/25, say 23/9/25, there is no cess payable. What do I do with the input cess? Let's see what we can do. Let's look at the provision, see where it helps us to at least do something on this. Now, as far as cess is concerned under the Compensation Cess Act, most of the provisions of the CGST Act are borrowed, sir. Most of the CGST provisions are borrowed for the Compensation Cess Act. That's why value under the GST is adopted for compensation cess. Everything is borrowed from there. Now let's look at some of the definitions of exempt supply, because your motor vehicle is exempt from cess. Therefore, let's look at the definition of exempt supply. Exempt supply means supply of any goods or services which are taxed nil rate of tax or which may be wholly exempt from tax. 1. 2. If you look at section 18(4), it says if the goods are exempted from tax, then the credit should be reversed and payment of such amount, the balance of credit will lapse. Does it mean that the cess that is in your books of accounts, since it cannot be utilized for payment of any output cess, that credit will lapse?
Is it not undue enrichment of government?
That's always there, sir. That's always there. I am only looking at, yes, sir.
One thing is there, if the dead asset in my balance sheet, I have to carry it out every year. Can I put my PL account to reduce my profit if the cess is not utilized for me?
So the problem is, this is the GST law. It applies only to the applicability or non-applicability of GST. What it would have as an impact under the income tax law, in terms of which only you can either reduce or increase the assets.
How can I reduce my assets? This is my problem.
Yes. Now, therefore, that's a serious problem we have, where there is a conflict between the intention of the government to reduce the cess, combine it with GST law, because now what has happened is on your output tax, the effective rate of tax has now remained the same, which is 28 plus 12. But as a character, it is not there today. Now, this is the provision as it stands today. Now, let's look at it from an inverted duty perspective. Because now what happens? Your input cess was 10%, your output cess is 0. So, can I now claim refund of the 10 rupees which is the input cess? Now, let us look at section 54(3), which provides for refund of inverted duty structure. Subject to the provisions of subsection 10, a registered person may claim refund of any unutilized input tax credit at the end of any tax period, provided that no refund of unutilized input tax credit shall be allowed in cases other than zero rated supplies made without payment of tax, which is export. 2, where the credit has accumulated on account of rate of tax on inputs being higher than the rate of tax on output supplies. No difficulty. Your rate of tax on inputs is higher than the rate of tax on output. Till here we satisfy it. Other than nil rated or fully exempt supplies, except supplies or goods or services or both may be notified. Now, from the inverted duty structure, what is excluded is other than nil rated or fully exempt supplies. Can we say that my output product is not nil rated or fully exempt because it is subjected to a tax? It may not be subjected to cess, but it is subjected to tax, which is 40%. If it is subject to tax at 40%, can we therefore say that there is a situation where the credit has accumulated on account of my input cess being higher than the output cess? My output product is not exempted, it is not nil rated, therefore I should be entitled to claim refund of the unutilized input tax credit. According to me, it should be possible to do it. It should be possible to argue that my output product is not exempt and therefore I will be entitled to claim refund of the.
That's a most reasonable interpretation.
Yes. But that's something which people have to look at. Because people like you who are advising maybe coal companies or motor vehicle companies, etc., you should seriously consider whether that is an approach which we should be in a position to take.
Sir, in case of tea company,
Yes,
we
sir.
produce tea, and
Please,
coal,
sir. Please, sir.
coal has been purchased and coal has not been sold, it is consumed for production of tea. In that case,
Come again, sir?
tea manufacturing company,
Yes.
they have purchased coal
Okay.
for resume the coal for production of tea.
Okay.
In that case, the sales is the asset of the balance sheet.
Correct, sir.
ITC sales is also carried from 2027.
It's already-
2017.
It's already taken also. Correct.
Can I get any remedy for refund Otherwise, can I get I mean, vacate that asset? The procedure of the any kinds of finance act.
But your output T is being exempted from cess from today.
Yeah.
Or even yesterday it was cess was payable.
Yeah.
Cess was payable.
No liability to pay tax, only 5% GST. And auction sale is there. They are
Now this 5% reduction has happened from now, or it was there earlier also?
earlier also.
Earlier also it was there.
Mr. Shivdas, we are running short of time. Please explain it as early as possible.
No problem, sir. No issues. Done. Now, no issue, no problem, sir. So, this is something which we should seriously consider, whether it is possible to do a inverted duty structure refund. I'll go to the next problem, which I would not say problem. I'll keep it like this. Now, there are a lot of registered and unregistered clubs, like your maybe a West Bengal Cricket Association and all that. Lot of registered clubs will be there. Now, there are members of the clubs. So, the club will be providing certain services to the members. So, when the club provides services to the member, whether that is taxable was always an issue. Whether when a club provides services to its members, whether that is taxable was always an issue. Kerala High Court. Now the Kerala High Court has said that even in GST law, since Constitution has not been amended, by which a member and a club are not considered as distinct people, even under the GST law, there is no supply of service from the club to the members. This is a very good decision of the Kerala High Court, explaining this entire concept. Now the issue would
Followed
be,
recently by another court also.
yes sir,
Very recently.
yes. And of course, the government has preferred an SLP in the Supreme Court. That's still pending. But what would be the impact of this? Would it have an impact on transactions that happen between the head office and the branch office?
Mr. Shivdas, as far as AIFTP is concerned, we have also filed intervention application to the Supreme Court.
Very good.
We are also party to this.
Good, sir. So, in fact, this decision explains how the amendment in GST law that has been made subsequently is contrary to the provisions of the Constitution. Now, if this theory is upheld, even between the head office and the branch office, there cannot be any supply of service. This concept of distinct persons will lose its validity.
Correct.
Even under the GST law.
It is beyond the Constitution.
Beyond the Constitution. Now, that's something which companies are looking at. That is how you have to look at the original circular of the government saying that between the head office and branch office, if invoice is not raised, value is nil, accepted, all of them will fall into a pattern. So, this is something which people should really look at.
Mr. Shivdas, let us conclude as early as possible.
Okay, sir. Now, this is the decision in safari retreats. All of you would have been aware of it. Where input tax credit can it be given in a situation where inputs are used for immovable property. The Supreme Court has explained this concept of what do you mean by immovable property. what is plant or machinery, etc. They have explained all this.
Plant or machinery.
Plant or machinery, they amended it retrospectively to say
has
that it's
been
plant
amended.
and machinery, etc.
That has been amended also.
Yes. But what is more important in this decision is to see whether, suppose your immovable property is used for further leasing. So you construct a mall and you lease out the mall. On the lease rent you pay the tax. Can you still be denied the input tax credit? Is something which companies have to look at. In my view, this Supreme Court decision itself can be used to say that you will be entitled for the input tax credit. Yes, Safari retreats and all their, the SLP, the review also has been dismissed in Safari. There's a very nice discussion on what do you mean by on-own account, what do you mean by, how do you decide whether it is a plant or not. All that has been discussed in the decision.
Go by 17.5c only.
Yes, 17.5c. Now I'll touch on the last topic of the powers of the revisional authority. This is something which the government seems to be, at least some of the state authorities, central authorities are not doing it so much. Some of the state authorities are doing it. This is the revisional powers, all of you would know, where if there is an order of the appellate authority in favor of the SSC, the government can review this order and say that we would like to take it up on revision. Now, the question that is coming up is, the time limit fixed is about 3 years for them to conclude the conclusion. Whether it should be, entire exercise should be done within 3 years, or it is enough they start the process within 3 years and conclude it later. That's one big issue that is coming up. That also you people need to take a call on how to handle it. Okay, sir? Any number of issues are there, but of course the session is too short for it. Thank you so much.
Thank you, thank you. Thank you, Mr. Shivadas. It has given me a good opportunity for brainwashing. Friends, Mr. Shivadas has given you good items, good food before you go for lunch. And I must, on behalf of all of you, thank Mr. Shivadas for wonderful see, somebody says that if the GST was so simple and if it was so good, the need for such a seminar would not have been there. So, the experience of last 7 years is that it is neither good nor simple, as they say. But the definition of simple is yet to be asserted. So, over to you. Thank you, Shivadas sir. Thank you very much.
Thank you, sir.
Sir,
Thank
can I take up one issue, sir? You are a constitutional expert. This logistic.
Okay, okay, sir. We'll take it offline, sir. We'll take it offline.
You can have it on the lunchtime, you can take his help.
Surely,
But
surely.
then, there is no time now. Please.
Thank you, sir. So, thank you, Joshi sir, for your wonderful moderation of the session. Thank you, Shivdas sir, for a wonderful deliberation. I would request Ankit Bothra to please come and offer the formal vote of thanks.
Good morning, everybody. On behalf of the organizer, I thank Shivdas sir for his enlightening session and giving us thought-provoking ideas on the recent controversies that we are dealing with in GST. And I also thank the participants for having a patient listening, giving your time this Sunday morning. Thank you all.
Thank you so much, sir. We would be starting with the zonal award session immediately. So request you to please be seated. Thank you.
Thank you, sir. Sir, please. Sir, I will request Premlata ma'am to please come up on dais to give the zonal awards, which inspired the zone to perform much better. Shyam, please escort ma'am. Sir, zonal award, that's me. इसके बाद श्याम ऐसे डिटेल पूछ इसके बाद इसका प्रेजेंटेशन We start with the zonal award. First award goes to Sri Rajesh Kumar Mishra for the best upcoming speaker. Rajesh bhai. Ranchi One Day Conference, which had the highest number of delegates. Conference Chairman Shri Subrata Das Gupta, along with his team, please come up. Along with Ranchi Conference, we have another one-day excellent conference held in Patna, led by Smith Saurabh. As Smith has been content, let the Patna team come up and receive the award. Ashish bhai, come. Some people of the zone, young guys who have come up brilliantly upward. First we have Shyam Agarwal, GA, who is a new member and working brilliantly, hardworking, best outstanding support. Followed by Ankit Botra. Followed by Rohit Pundar. Sumit Ginoria. Sandeep Paul. Rakesh Kumar is not the I request Ashish bhai to collect it on his behalf. Chetan Patel. Prashant Kumar Mishra. Chandra Hota, अपूर्व शाह, किसका ये? अपूर्व शाह, एक बार कोई भी दे दो पीछे। सुब्रतो दास गुप्ता, रमेश कुमार, नवनीत कुमार, नीरज कुमार नायक, now for the best vice chairman who has worked tirelessly to make us so lively, energetic, and had a wonderful one-day conference. I would like to welcome Sri Ajay Kumar to please come up on the stage. Padmanand Dave. Sri Padmanand Dave. Sri Devashish Mandal. And last but not the final, Surijit Maheshal. Thank you.
Thank you, Bia. Now we'll have a presentation from Taxonation. So over to them.
Hello, hello.
It's a 5 minutes presentation and then we'll start with the next technical session. Thank you.
हेलो 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 ये लैपटॉप उठा दीजिए नहीं नहीं I don't need. ये आप हटा दीजिए ये चला नहीं वहाँ पे चला नहीं हाँ वो कर रहा है ओके अच्छा रख नहीं पेन ड्राइव नहीं ऑडियो वीडियो कुछ भी है नहीं 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 यही है वो देखो ना ऊपर आ गया
Hello everyone, I'm Sahil Bansal from Taxonation. I'll just take 5 minutes of all of you. Basically, Taxonation is a GST and income tax e-library. Yes, sir? So Taxonation is GST and income tax e-library which will very helpful for you in your professional life, as you all know there are so many frequent changes in GST income tax and you do not have that much time to read books and update on a daily basis. That's what we have made something from which you can access from your phone, from your laptop, from anywhere. You just need internet, nothing else. So this is a joint venture with Bharat Publication. As you are aware of the Bharat, This is our home page in which you will get updated news, articles from here as well as your mail on your WhatsApp. We will provide you our ID and password from which you can access from anywhere, from phone, from laptop, from desktop, anywhere. There is two module, income tax and GST. We just have launched GST GPT as well. You all are using Chat GPT, Gemini, AI, फ्री AI आप सब यूज कर रहे हैं, बट ड्यू उसमें बहुत सारे गलत है चीजें, बट हमारे GPT में आपको जो भी मिलेगा सब हेल्यूजन फ्री मिलेगा क्योंकि सारा डेटा हमारा ही यूज होता है. Let me start with the GST. GST cover act, rule, notifications, circulars, case laws, tax rate, articles, news, due date, videos, blog, deadline है single place. केस लॉ, आपको केस लॉ कहीं नहीं मिलते हैं, आप कितने बुक्स पढ़ लीजिए और गूगल कर लिए कहीं नहीं मिलते, बट यहाँ पे इंडिया की हाईएस्ट जीएसटी केस लॉ 17,805. हर केस लॉ का सेक्शन, सब्जेक्ट, ब्रीफ बाहर गिवन होता है. इफ यू क्लिक दिस जजमेंट यू कैन रीड इन एनी लैंग्वेज अपार्ट फ्रॉम इंग्लिश, हिंदी, इंग्लिश, बंगाली, गुजराती, जो भी आपको लैंग्वेज रीड करनी है. इफ यू डोंट वांट टू रीड यू कैन लिसन एज वेल. आप पढ़ भी सकते हैं, प्रिंट, मेल, डाउनलोड कुछ भी कर सकते हैं. जजमेंट किसके फेवर में हुआ है, इसकी समरी क्या है, बाकी पूरा जजमेंट नीचे गिवन होता है. अब इस जजमेंट में 4 जजमेंट भी रेफर्ड हुए हैं, दैट इज ऑल्सो क्लिकेबल लाइक दिस. यू कैन सर्च, देयर इज सो मेनी सर्चिंग ऑप्शन. यू कैन सर्च थ्रू कोड, सेक्शन, सब्जेक्ट, टेक्स्ट, ईयर, पार्टी नेम इन फेवर ऑफ एनी. Courts covered Supreme Court, High Court, AAR, AAR, NAPA, all courts, let's say High Court. DAY-2 you want to find on section 129. DAY-2 in the favor of assessee, submit, is take hardly 2 or 3 seconds and here's the result, 470 judgments. आपको स्पेसिफिकली कोई कोर्ट का चाहिए, जैसे कैलकाटा हाई कोर्ट का चाहिए 129 पे assessee के फेवर में, आप वो लिखेंगे 41 जजमेंट्स आ गए. एवरी जजमेंट्स कंटेन देयर ब्रीफ एज वेल, सो आपको पूरा पढ़ने की भी नीड नहीं है. नोटिफिकेशन सर्कुलर्स रात में सुबह कभी भी आए सेम टाइम अपडेट हो जाते हैं. ग्रीन कलर डिनोट्स नो अमेंडमेंट टिल नाउ, येलो मींस देयर इज सम अमेंडमेंट, रेड मींस गेट सस्पेंडेड, विथड्रॉल्ड. यू कैन सर्च, देयर इज सो मेनी सर्चिंग ऑप्शन. लेट्स से आई वांट सर्च 12/2017 नोटिफिकेशन, जिसमें आज तक सब चेंजेस आए हैं. इफ यू क्लिक दिस, आप बुक्स में आपको नोटिफिकेशन मिल जाते हैं बट अपडेटेड नहीं मिलते हैं. बट इसमें मेजर चेंजेस क्या है कि अगर एक नंबर पे कुछ ऐड हुआ है तो वो यहीं पे लिखा है कि इंसर्टेड बाय नोटिफिकेशन नंबर दिस विद इफेक्ट फ्रॉम दिस, नोटिफिकेशन इज क्लिकेबल. एंड कुछ ओमिट होता है तो हम स्टार नहीं करते, हम यहाँ काट देते हैं. तो अगर आप प्रिंट या डाउनलोड करेंगे आपके पास अपडेटेड नोटिफिकेशन होता है. एक्ट, सीजीएसटी है, जैसे स्टेट, यूटीएस सारे एक्ट है. सीजीएसटी एक्ट में भी लेट्स से यू वांट टू रीड ऑन सेक्शन नंबर 16 और व्हाटसोएवर, इफ यू क्लिक ऑन केसेस, ये सारे केसेस ऊपर हो जाएंगे सेक्शन 16 के. कौन से रूल्स आपको इसके साथ पढ़ने हैं, DAY-2 इज गिवन, DAY-2 इज क्लिकेबल एंड ऑल द अमेंडमेंट्स गिवन अंडरनीथ with updation, with their notification, with their effective date, which is also clickable. Same for the rules. This tax rate HSN code. Goods services. Goods is also bifurcated into 3 schedule, chapter exempted. In chapter wise you will get 4, 6, 8 digit HSN code. Let's say chapter 2 में open करता हूँ. This get nil by from this date by this notification written over here, and 8 digit HSN code is also given over here as well. You can search through HSN or name. Let's say I write Haldi in Hindi and enter. Here you go. Just single click Haldi. Fresh dried powder, 8 digit HSN and rate is given over here only. There is articles which is written by different practitioners, CA and advocate, which you can read forms, draft reply. We have made some draft reply ready to use. आप अपने litigation matter में इसको use कर सकते हैं. In case law compendium, what we do, we converted landmark judgments into question, then we give answer whether yes or no. किस जजमेंट में बोला गया है, क्या बोला गया है और ऑथर से कमेंट क्या है. न्यूज, वीडियोस, ब्लॉग डेली यहाँ पर भी आते हैं, आपके व्हाट्सएप पर भी आती है. अगर आपकी कोई क्वेरी रिगार्डिंग जीएसटी या इनकम टैक्स आप हमसे पूछ सकते हैं, हमारे एक्सपर्ट उसका रिप्लाई करते हैं विद इन 24 आवर्स, दैट टू ऑफ फ्री ऑफ कॉस्ट. देयर इज टोल फ्री नंबर एज वेल, आप कॉल करके भी डिस्कशन कर सकते हैं. रिसर्च एक हमारा टैब है इन विच आप कोई भी वर्ड लिखे उसकी रिगार्डिंग कुछ भी होगा पूरे जीएसटी में आपको एक जगह ही मिल जाएगा. लेट्स से मैंने हल्दी ही लिखा था, सेम वर्ड. हल्दी पे जजमेंट, HSN, कॉन्स्टिट्यूटिव नोटिफिकेशन, 4 चीज आप कुछ भी क्लिक करके पढ़ सकते हैं. इसके साथ मैं अपना जीएसटी जीपीटी जो अभी रिसेंटली लॉन्च हुआ लास्ट मंथ ही, मैं इस पे आता हूं. इसमें 4 ऑप्शन है, जनरल क्वेरी, एक्ट, रूल, केस लॉज, ड्राफ्ट रिप्लाई. इन जनरल क्वेरी यू कैन आस्क एनी क्वेरी रिगार्डिंग जीएसटी. मेन चीज इसमें आंसर हो सकता है कम दे, लेकिन गलत एक भी नहीं देगा क्योंकि वो हमारे डेटाबेस के अंदर है, जो डेटाबेस हम सालों से इकट्ठा कर रहे हैं. लेट से आपको केस लॉ ढूंढने हैं, मैं लिखता हूं मिसमैच बिटवीन GSTR 3B and GSTR 2A. मेरे को इस पे केस लॉ चाहिए, मैंने केस लॉ पे क्लिक करके अपना फैक्ट्स लिखा और हियर इज अ केस लॉ. तो आप बेसिकली कुछ भी लिखिए, कोई भी फैक्ट लिखिए, कोई भी टॉपिक लिखिए, उस पर जो भी केस लॉ होंगे आपको यहाँ पे मिल जाएंगे। एंड एवरी केस लॉ कंटेन देयर लिंक एज वेल। आपको पूरा केस लॉ पढ़ना है तो आप लिंक पे क्लिक करके पढ़ सकते हैं। एक ऑप्शन है ड्राफ्ट रिप्लाई, जिसमें आप बहुत लोगों को यूजफुल है। लेट्स से मेरे को मेक ड्राफ्ट रिप्लाई ऑन रिवोकेशन ऑफ कैंसिल्ड रजिस्ट्रेशन। मेरे को इस पे ड्राफ्ट रिप्लाई बनाना है। मैं इस पे लिखूंगा, पूरा ड्राफ्ट रिप्लाई बनकर आ जाएगा। आपको जितना बड़ा बनवाना है, जजमेंट चाहिए इसके अंदर, आपके फैक्ट्स आप यहाँ पे लिख दीजिए, वो आपको ड्राफ्ट रिप्लाई बनाकर दे देगा। मेन चीज इसमें कोई भी एलिगेशन नहीं है, एक चीज भी इसके अंदर गलत नहीं है, सारी ऑथेंटिकेट, बिकॉज दिस इज आवर डेटा। अपार्ट फ्रॉम दिस सेम इज इनकम टैक्स, जो मैंने आपको जीएसटी में दिखाया, एक्ट, रूल, नोटिफिकेशन, सर्कुलर, एवरीथिंग इज सेम ओवर हियर। बस इनकम टैक्स में जजमेंट जो है 1932 से है, जीएसटी में जजमेंट 2017 से है। दिस डीड एंड अलाइड लॉ, ये दो चीज भी आपको मिलती है एज अ कॉम्प्लीमेंट्री। इन अलाइड लॉ यू विल गेट 78 बेयर एक्ट्स अपार्ट फ्रॉम जीएसटी एंड इनकम टैक्स, और उतने ही रूल्स मिलते हैं। So this is all my time. If anyone have any query, please do ask me. And for the price, we are providing 50% discount over here. If you go for GST only, after discount, it will cost you 6,000 plus GST for 1 year. And if you go for GST and income tax both, it will cost you 12,000 plus GST for 1 year after 50% discount. In that, GST GPT is also included. So if anyone wants to take another demo or any queries, I am outside and the front with the friend in the door. So please come over there on a stall and we can discuss more. Thank you.
Good morning, Suprabhat. Now we are moving towards our fifth technical session on caught in crossfire, third-party search, its constitutional fallout in income tax proceeding. And in the row, we first would like to request our chairman, Sri Jinesh Banjara sir, please come forward and grace the dais. Please come, sir. And now I would like request to the keynote speaker of the Tushar Pramod sir, Hemani sir, senior advocate. Sir, please come and grace the technical session. Please, sir, come. And the moderator of session is Sri Pradeep Kumar Agrawal ji. Please come forward. Before we going to start our technical session, we have a short felicitation program, and we, in the row, we first felicitate our chairman of the session, Sri Jinesh S. Banjara sir. कौन आएगा? श्याम, कौन नाम कौन? And I would like request to Sudeep Napani ji, our zone secretary, please come forward and felicitate our chairman of the session, Sri Jinesh S. Banjara sir. Please come, sir. Please give a big round for applause for Dinesh Banjara sir. Please. And in the second, in the row, and I would like request to Bhaskar Sinharai. Bhaskar Sinharai, please come forward and to felicitate our keynote speaker, Tushar Pramod Hemani sir, senior advocate. Please come forward. Please give a big round for applause for our keynote speaker of the today's session. And in the next, in the row, and I would like request to Devashish Mandal, please come forward and felicitate our moderator of the session, Sri Pradeep Kumar Agrawal ji. And before going to start the technical session, this crucial section and the caught in crossfire, just we introduce our keynote speaker and the chairman of the session. And I would like request to Shyam Agrawal, please come forward and introduce our keynote speaker and chairman of the session. Please.
Thank you, Rajesh Bhaiya. A warm welcome to all the dignitaries here present on the dais and off the dais. I would like to introduce our speaker of the day, Mr. Tushar Pramod Hemani. He is a senior advocate practicing in the fields of direct and indirect taxation, corporate, commercial and fiscal laws before the Honorable Supreme Court, High Courts, Tribunals, Commissions and other judicial authorities. One of the youngest at bar to have been conferred senior designation by the Gujarat High Court in the year 2019. A big round of applause for sir for his commendable achievement. He is the chairman of the Direct Tax Committee of the All India Federation of Tax Practitioners for the term 2025, vice chairman of the AIFTP's ITIT Bar Association's Coordination Committee, president of the Income Tax Appellate Tribunal Bar Association Ahmedabad, member of the Direct Tax Committee of Gujarat Chamber of Commerce and Industries, editor of the book titled New Reassessment Regime, Law, Procedure and Practical Guide published by Taxman in 2025. He is a regular speaker at various conference, seminars and meetings and a regular writer of columns, articles and newspapers. He is also a visiting faculty of taxation and corporate laws at various institutes and colleges. We welcome sir on the platform of AI. Thank you sir. Thank you so much. Over to Chairman sir. Over to Chairman sir for his opening remarks.
So, on the dais, Mr. Hemani, we have a senior counsel from Gujarat. All the seniors I see of AIFTP and Pradeep Agarwal, a colleague. Good morning to all of you. Caught in crossfire third-party search and its consequential fallout in income tax proceedings. I was told by Hemani ji that he may also like to touch, apart from income tax, maybe some other GST or PMLA third-party fallout as well. A crossfire caught, even the direct person who is searched, he is also caught into crossfire. Between the lawmakers, the intention of the law, and the bureaucracy who interpret the law in their own way. Third party तो बाद में आता है, जिसकी search होती है, the people who handle searches, we know, we understand for years, उनके यहाँ कितनी crossfire में वो फंसे रहते हैं बेचारे. So, before, I will request the speaker to take over. I'll take 5-10 minutes. I know we all come to hear him out. 22 years ago, a very senior industrialist from Calcutta, I was working for him. So we were going to a very senior council in the city. So जब भी senior council कोई बात करे in favor of revenue, you are wrong on this side. And he will speak very ulti baat in favor of SSC. तो मैं निकल के पूछा कि सर ये इतने सीनियर काउंसिल है, आप ऐसी बात इनको क्यों इतना गर्म करते हैं? बोला देखिए बंजारा जी, आप तपाएंगे नहीं ना लोहा, तब तो वहाँ से निकलेगा ही नहीं गर्मी. तो whenever you go to a senior council types, आप अपना उनको पहले गर्म कीजिए 5-10 मिनट, फिर उसमें से बेस्ट आएगा. So I think the job of a chairperson on such sessions, मेरे को कुछ 5-10 मिनट बोलना पड़ेगा उनको तपाने के लिए. And then maybe we get the best out of Mr. Hemani. Right, Mr. Hemani? Thank you. So maybe 90-minute session mein, it may not only be relating to third parties. It's a very interesting topic, very vibrant as well, for those of course who are interested in such discussions. We had this 158 BCBD proceedings from 95 till 2003. And then there was the famous Kolkata case, Shaw-Wallace, which went up to Supreme Court. And there were disputes on taxability of certain income as regular income or block income, 60% or 30%. कुछ भी they used to find out in the course of search, the department would try to tax it as undisclosed income, and the SSU would say, sir, ये तो regular nature की income है. So to overcome this, Supreme Court, सरकार में क्या होता है, if you have a headache, they don't give you a pill. Stopic नहीं देंगे, वो माथा काट देंगे, खत्म करो, झमेला ही नहीं चाहिए. So they did away with this 158 BCBD, they brought this 153A and 153C. फिर वो झमेले चले, nothing found in the course of search, can you tax it as a block income, as a search income? We had this Kabul Chawlas and all these so many case laws. So ultimately board में जब सब ये भर्ती हो गया, 2020 में somebody in TPL came up with new ideas, 153AC को भी scrap कर दिया, 148 ले आए. 3-4 साल ये 148 का तमाशा चला, and of course for professionals like us, काफ़ी काम निकले हम लोग के, kept us busy, and we are still busy on this 148 matters. तब ये 24 सितंबर में जाके again they brought back the block. But I tell you, Hemani Saab and my friends, abhi bhi that moot issue, taxability of certain income as block income to be taxed at 60% or as regular income, which is maybe 25% now or 22, whatever it is, still remains, partially of course. If you go through the new law which they have made now, 292, 293, 294, 5, etc., abated years search पे जो year 5 or year 6 होंगे, if additions are made by the department, they are going to take it as undisclosed income. We have raised this point, I have particularly raised this point a number of times before board and RS and all, but it still remains in the new act as well. Maybe you can throw some light on this, sir. So then I said, sir, there are regular technical issues of any corporate. बरसों से कोई ट्रांसफर प्राइसिंग का, कोई डेप्रिसिएशन, सो मेनी लीगल इश्यूज, ATI भी, विच इज़ ऑन. सो लास्ट 2 years जो अबेटेड वाले हैं, उस पर भी वो डिपार्टमेंट ऐड करेगा, दे विल कंटिन्यू. हाउ कैन दिस बी टर्म्ड एज अनडिस्क्लोज इनकम? बट in the year 7 broken period, there is a way of dual taxation, but in so far as year 6 and year 5 are concerned, there is no dual taxation. So this anomaly still remains, and we are yet to solve this mystery, sir. Coming straight to third party, there are different approaches in third party insofar as 148 was there and 153C was there and now 158BD is there. Evidence found in the course of search at somebody's place. What is its fallout insofar as Evidence Act that we had till now being a new law name is there. So we'd like to hear from you, sir. We had the Supreme Court decision on evidentiary value and the differentiation between the fiscal law, civil law and criminal law. We are fiscal law, we are neither civil nor criminal insofar as income tax is concerned. So we can't always take this umbrella of Jain Hawala Diary and Sahara Diary, etc., because they were all basically criminal laws. We still have a tendency of quoting these case laws when we appear before the income tax also. Sir, in the new act which has come now, 2025, when you talk of third party, we also talk of third party summons. किसी के यहाँ search हुई, वो 133(6) करते थे. 133(6) को अभी 258 something 253(5) भी किया है. Statement on oath लेने की बात की है. And 252(1)(a), which is akin to 133(6) of the previous law, they have introduced 2 new words, requisite information. पहले 133(6) में आपसे मांगते तो only which was relevant. This requisite information is a very vast term and is very subjective and relative. So I do not know how they are going to treat the third parties. Sir, in the third parties when you talk of, we would also like to hear you, पुराना जो 132(4)(a) presumption था, how far this presumption is valid for the person who is searched or from whom the search documents have been found, and how far is this relevance of this document in so far as presumption is concerned on a third party? To my understanding, sir, this is all not arithmetic. This presumption has to be examined with facts. किसी के यहाँ कागज मिला है, खाली कैश में आपका नाम लिखा है, आप कहेंगे नो नो देयर इज नो प्रिजम्पशन अगेंस्ट मी. उसके साथ आपके लेजर में चेक भी लिखा है एंड दोस चेक्स आर मैचिंग इन योर बुक्स और साथ में नीचे कैश की भी एंट्री है, तो आई थिंक प्रिजम्पशन इंक्रीजेज. सो टू माय अंडरस्टैंडिंग प्रिजम्पशन कोई एरिथमेटिक नहीं है फॉर्मूला कि 132(4) में उसका प्रिजम्पशन उसी पे आएगा, मेरे पे क्यों आएगा. लॉ डजंट एनविसेज दैट. आई डोंट थिंक वी कैन से दैट. वी लाइक टू हियर अ लिटिल फ्रॉम यू सर, एंड मे बी इन द process of discussion we'll have a lot of questions in the end. I will request you carry on for as long as you want sir, maybe 60-75 minutes. We have a 90-minute session, and towards the end or after he finishes we can have an interactive question answer session which should be more interesting. And even I have a lot of points to post sir, so जैसे जैसे session बढ़ता है we'll take that opportunity. Thank you and you are welcome sir.
Good morning. Audible? यहाँ दिख रहा है ना? हाँ हाँ, यहाँ से भी चलेगा ना? हाँ, ठीक है. Thank you. Good morning, friends. As they say, Subho Sokal. Correct me if I am wrong. Always a pleasure to be in the land of Tagore and Vivekanand. जिनेश भाई ने लोहा गर्म कर दिया है. So we'll have a great interactive session. But before we go there, let us build the platform for that. What I plan to do is, I plan to divide this 90 minutes session into broadly 2 parts. The first, I talk, you listen. And second, we all talk and we all listen to each other. Probably 75 minutes I'll be taking, 11:35 to maybe 12:45, and thereafter we can have some question answers. Look, this has been a burning issue, as I was told by Vivek Bhai when I had a talk with him. He said that Calcutta today what we have is we have a lot of third-party searches, and as a consequence, there are either remedial actions or there are assessment proceedings where the third-party search material is used. And in an extreme case, maybe there is a survey or a search as a consequence of a third-party search, or if it is a search post 2024, 1st September 2024, then probably initiation of block assessment proceedings as well. Once I run through the slides and run through the presentation, probably most of the issues raised by Jinesh Bhai would also be answered, because I'll be briefly touching upon the block proceedings as well. And what has been done is the block proceedings, the new block assessment scheme under 158. Ji, please. No problem. 158, which is now reintroduced, and that is converted into 2025 Act without probably some minor grammatical changes here and there. So once we cover the block scheme, probably we would have covered 2025 Act as well. With this, friends, let us look at the searches. Third-party searches are various. Now we have searches not only under the Income Tax Act, because the remedial measures could be taken not only for income tax searches, but also for large number of other searches.
GST is one other example where there is a GST search. GST visits someone's premises. And mind you, GST searches are far less cumbersome than income tax searches. Under section 67, the powers are given, and those powers are very routinely exercised by the GST department. So they visit someone's premise, they find that, oh, we find lot of bills, but there is no physical movement of the goods, or we do not find any physical goods. So probably this party is only into billing transaction. Once they say that this party is only into billing transaction, they might take the consequential action by issuing either notices under 73, 74 or go for cancellation of the registration. Maybe in some extreme cases with retrospective effect, that is ab initio cancellation, so on and so forth. And as a result, now we have information backbone whereby departments, they share information on a routine basis. And GST is again based on PAN. So the moment those information is there, they are disseminated, the assessing officer concerned, not only of the search person under GST Act, but all those who have transacted with that person and the onwards transaction. Supposing I am purchasing from A, selling to B, A is searched, found to be a bogus biller, not only I am considered as a tainted party, even the step down, namely someone who is purchasing from me is also considered as a tainted party. So all those PAN are now connected, the information is shared. Once the information is shared, income tax department would start issuing the notices that, sir, you have either availed a bogus ITC, or your purchases are non-genuine, or you have traded with that party in some manner, and therefore your accounts are also tainted, your income is not correctly disclosed, there is an escapement, we'll take remedial action in your hand. PMLS searches. Then we have those proceeds of crime, and once the proceeds of crime is tagged as such that this is nothing but a proceeds of crime, then again the consequential search on the ground that this is probably an item of income which has arisen from an undisclosed illegal source, or we call it from the scheduled offense. And if that is earned out of scheduled offense, then again the income tax department would be intimated. Then the question would be, insofar as income is concerned, whether it is legal or illegal, taxability would take place. But insofar as expenditure are concerned, we have a problem. The moment they say that this is an illegal activity, your entire expenditure would be disallowed, because now Supreme Court has a different view on the allowability of all such expenditure. SEBI search, there is a market rigging. The allegation is that you are rigging a particular script, and the transactions, the trades under those scripts are artificially rigged up. Again, the gains are not real, not genuine, and therefore SEBI would disseminate the information, and those searches again will have repercussions under the Income Tax Act. Allegation is that this is the gain that you are showing and claiming exempt or paying lesser taxes under the head capital gain is nothing but an income under section 68, and therefore 115BB, and therefore to that extent there is a suppression of income, escapement of income, remedial measures. Police searches, random search of vehicle, police searches, a cash is found, a bundle of currency notes are found, or some jewelry, bullion, valuable articles are found and not properly explained. Police, unless it is a crime which is committed and that income is directly related to the crime, would not be keeping the same as a muddamal, as they call it, and they would be informing the income tax department under 132 capital A and hand over the same to the income tax department. Department will treat it as if it is nothing but arising out of a search, and they will start all the necessary consequential action under the Income Tax Act. Railway police again will follow the same steps. Airport CIFS, again the searches would have the same repercussions as mentioned, that 132A requisition would take place. So these are all different searches. I have given few examples. There could be other actions as well under large number of other statutes. And ultimate, what we are concerned today is that what is the fallout under the Income Tax Act, that whether that would kind of put an assessee into a position whereby his past assessments would be reopened, or whether that material can be used for the purpose of framing the current assessment. So what would be the fallout under the Income Tax Act? What actions can be taken?
Look, today my endeavor is, let me tell you a story. I would be taking you there, but not frankly giving you any specific answers. Let me tell you a story to put across the point that what is the endeavor today. एक गुरु थे, बहुत महान थे. उन्होंने अपने चेले को बताया कि एक ऐसी जर्नी पे चलते हैं, एपिक जर्नी, कि वहाँ तुम पहुँचोगे तब तुम पागल हो जाओगे. सो चेला वॉज रियली एक्साइटेड कि सर कहाँ ले जा रहे हैं मुझे, लगता है ये लाइफ चेंजिंग एक्सपीरियंस है, इससे पूरा मेरा लाइफ चेंज हो जाएगा. सो उन्होंने जर्नी शुरू की. पहाड़, रण, नदी, एवरीवेयर दे पास थ्रू. चेला को लगा कि अभी डेस्टिनेशन आ जाएगा, पता लगेगा वो क्या वंडरफुल चीज़ है. उसको लगा वो एनलाइटनमेंट वहाँ से मिल जाएगी, मेरी लाइफ सफल हो जाएगी. आफ्टर 30-40 ईयर्स जर्नी चलती रही. एक दिन वो एक जगह पे पहुँचे, वहाँ दिख रहा था कि सामने पूरा समंदर है, रास्ता बंद हो चुका है. गुरु वहाँ बैठ गए, बोले ये डेस्टिनेशन आ गया. वो चेला वॉज रियली डिसअपॉइंटेड. बोले सर मैंने पूरी लाइफ आपके साथ बिता दी, आपने बोला ऐसी जगह ले चलूंगा जहाँ जाके पूरा कल्याण हो जाएगा, यह तो कुछ है ही नहीं. बोले तुमने कभी बात को समझ नहीं पाए. तुम, योर जर्नी वॉज द डेस्टिनेशन. द होल आइडिया वॉज दैट जर्नी पूरी थी, वही ज्ञान था, डेस्टिनेशन पे कुछ होता ही नहीं है. सो दिस इज टुडे माई आइडिया इज that the journey, I'll show you that how a problem is required to be interpreted. I'll show you how you can find your answers, but I'll not giving you any specific answer कि सर ये केस लो लगा दो, ये सिचुएशन है. तो नहीं, ऐसा नहीं है. मैं आपको बताऊंगा कि ये ऐसे इसको एनालाइज करते हैं. दिस इज हाउ यू कैन फाइंड द आंसर फॉर योर सेल्फ. दैट इज द आइडिया. सो क्या क्या हो सकता है, दैट आई हैव लिस्टेड. दैट व्हाट आर द रेमेडियल मेजर्स. One and the foremost and the most widely used measure is 147. कि जैसे ही ऐसे कुछ जगह से चीज़ें मिलती है, anything which is found out, department will immediately issue a 147 notice कि भाई आपका लग गया, अभी आप यहाँ पे ये साल हम आपका रीओपन करेंगे. अगेन 21 to 24 के लिए 147 लगेगा. आफ्टर 1924 ब्लॉक्स की स्कीम लगेगी. ब्लॉक असेसमेंट फिर से बदल चुका है. सो वी हैव कम अप अ फुल सर्कल. 97 में ब्लॉक आया, 97 से 2003 तक ब्लॉक चला. आप उसका जब नई स्कीम आई थी 153 ABC, काइंडली हैव अ लुक एट द मेमोरेंडम एक्सप्लेनिंग द प्रोविजंस ऑफ द स्कीम, एंड दे सेड दैट ब्लॉक इज नॉट सक्सेसफुल, ब्लॉक हैज क्रिएटेड लॉट मेनी प्रॉब्लम्स, देयर आर लार्ज नंबर ऑफ लिटिगेशन, देयरफॉर वी आर अगेन कमिंग बैक टू द नॉर्मल स्कीम 153 ABC. 153 ABC चला. उसके बाद में नाउ अगेन 21 से नया लॉ आया. 21 से ये 147 में फिर से डाला उसको. अगेन 3 साल चलाया. 24 में लगा कि नहीं ब्लॉक अच्छा था सबसे पहले वाला. सो नाउ व्हाट वी हैव इज अ हाइब्रिड ब्लॉक. हाइब्रिड ब्लॉक है, उसमें थोड़े बहुत ब्लॉक के सिम्टम्स है और थोड़े बहुत 147 के सिम्टम्स है, एंड देन दैट इज हाउ दे कम अबाउट अ फुल राउंड सर्कल. देन सेकेंड वुड बी अगेन इफ इट इज अ सर्च पोस्ट 1924, आपके हाथ में 158 BD का ब्लॉक एक्शन लिया जाएगा. देन वील अगेन बी डिस्कसिंग व्हाट इज आफ्टर 24 147 वर्सेस 158 BD. इज देयर एनी कंकरेंट जुरिस्डिक्शन, इज देयर एनी कॉन्फ्लिक्ट ऑफ इंटरेस्ट, कैन यू इंसिस्ट एज एन SSC दैट सर ये आप 147 ही ले सकते हैं या 158 BD ही ले सकते हैं, या इट इज अ डिस्क्रिशन ऑफ द डिपार्टमेंट, और बोथ कैन वर्क साइमल्टेनियसली. दैट इज वन एरिया ऑफ कंट्रोवर्सी विल बी ब्रीफली टचिंग. देन आपका जो साल ऑलरेडी रेगुलर असेसमेंट में लगा हुआ है, द ईयर विच इज ऑलरेडी ओपन where the regular assessment is going on, and there whether all this material which is found from a third party search can it be used, because assessing officer now has access to that information. So मेरा ये साल का स्क्रूटिनी असेसमेंट चल रहा है, फाइनेंस ब्रोकर के यहाँ सर्च होती है, उसमें एक मटेरियल मिलता है उसको, और उससे लगता है कि आई हैव अर्न्ड सम unaccounted or unrecorded interest from giving money to that finance broker. Can that information, material or evidence be used for the purpose of making any addition directly in my case in the regular assessment? Then 138A requisition, मैंने आपको जैसे बताया रेलवे पुलिस या नॉर्मल पुलिस या एयरपोर्ट से कुछ मिलता है, and that is handed over to income tax department. What is the procedure and what is the way out in so far as those kinds of actions are concerned? And if you are extremely unlucky or एक जगह पे सर्च होती है, वो सर्च के दौरान कुछ पाया जाता है, देन दे डिसाइड के इसको ये जो मटेरियल है वो बहुत ही इंपॉर्टेंट है एंड दिस एसएससी इज ऑल्सो रिक्वायर्ड टू बी सर्च, सो एज अ कॉन्सिक्वेंस आपके हाथ में भी सर्च हो जाती है, तो क्या कर सकते हैं? दिस आर ब्रॉडली द इश्यू अंडर विच विल बी डिस्कसिंग फॉर नेक्स्ट अबाउट 70 minutes. Third party search induced reopening 147. This is again restricted to the searches which are taking place between 1/4/21 and 31st August 24. Because this scheme had that life. I'll take you to the relevant provision also why this scheme is relevant. Prior to 21, again 153 ABC would have been hit, but that probably is now academic because of the simple reason that 153A, 2 years are already over, therefore those assessments are already over. The consequential action under 153C, again as per the Supreme Court judgment, that action could be taken either at the time of finding the material, be at the time of assessment proceedings of the search person, or immediately after the framing of the assessment in the hands of the search party. So even 153C time limit is also over. All these cases probably would be pending in appeal, but that is not the focus as of today. Therefore, 147, the searches between 21 and 24 is the first issue for discussion. Any income chargeable to tax, again the language is changed now as against original language of reason to believe. If the assessing officer has reason to believe that income chargeable to tax has escaped assessment for ABC reason, as against that now any income chargeable to tax in the case of an SSC has escaped assessment. So the fundamental difference is reason to believe, which was subjective, could be the belief of an assessing officer, as against that now we have income chargeable to tax escaping the assessment. Therefore, we need a more concrete evidence as against the earlier scheme. This is how I would put it. And then explanation says that once the assessment is open, then not only the income which is originally the ground for reopening, namely the items which were subject matter of reopening, not only those additions, but any other addition which is coming to the knowledge of the assessing officer during the course of the reassessment proceedings can also be subject matter of addition. So put it simply, एक बार आपका assessment खुल जाता है reopening के अंदर, then not only the items of the reasons for reopening or the information which is subject matter of reopening action, not only those items, but any other item which may come to his knowledge can be subject matter of addition. Then 148 is more or less the same. What we want to concentrate is, provided that no notice under this section shall be issued unless there is information with the AO which suggests that income chargeable to tax has escaped assessment in the case of the SSC for the relevant assessment year. So information is something which is required to be kept in mind, because for our purposes, third party search as a fallout, आपके हाथ में कोई एक्शन, मेरे हाथ में एक्शन तभी लिया जाएगा जब there is some information which is there. Now what is that information which is suggesting that there is some income escaping assessment in my hand? Unlike the earlier scheme, there was again between 2021 and 2024 there was a minor change in the language from here and there. We will appropriate time, we will discuss that. But the issue today is that what is that information which would suggest that there is an escapement of income? For that, we have various types of information. We are not bothering about information which is coming lower down. The very first information, which is information based on risk management strategy. And the last information, that is 6, that is pursuant to survey. Search is specifically missing over here because that information is not falling under 148A3. What is there is risk management strategy. Now, if you ask me what is this risk management strategy, my answer is no one has seen that risk management strategy. Time and again, before various courts across the country, courts have asked question to the income tax department that, sir, kindly produce risk management strategy on record so that we know what is a risk management strategy. Except for one old circular of December 21, there is no other material. 21 also was not defining what is RMS, risk management strategy. It was only as regards these are the information which would be relevant for RMS and therefore can be uploaded by the local jurisdictional assessing officer. Other than that, no one has seen risk management strategy. The answer given by CBDT consistently before the court is that, sir, this is a dynamic algorithm which changes on a real-time basis. Therefore, it is difficult to define what is a risk management strategy. And I presume that risk management strategy would also include information which is shared on the ITBA portal insofar as third-party searches are concerned. Because except for that, there is no other provision, because now we all are aware that information-driven reopening can take place only if there is an information. Except for this 6, there is nothing which can be considered as information. So unless it falls in 1 to 6, any of this category of information, there is no information in the eye of law. If there is no information in the eye of law, there is no question of any reopening in case of any SSA. And therefore, I presume that RMS, the first category, is the only category under which department would be putting the cases of the SSC. And then comes the concept of dimmed escapement, because explanation 2 to 148 talks about dimmed escapement. Broadly, the dimmed escapement or dimmed availability of information is where there is a search. If there is a search at anybody's premise, then the information is presumed to be there, and therefore, to that extent, the officers would say that, sir, we don't need any information under any of these earlier 6 clauses, because the moment there is a search, we would presume that there is an information which is suggestive of the fact that there is an escapement of income. Now, kindly mark the difference. Difference is, the presumption is to the effect that there is an availability of information. Look, unlike 6 categories of information, unless you fall under any of these categories, there will not be an information. In the cases of search, the presumption is that there is an information which is suggesting that there is an escapement. And therefore, that presumption would come to the rescue of the department that yes, there is a dimmed information which is available. Now the question, the finer question would be that whether that dimming fiction, the presumption, is vis-a-vis the availability of information or vis-a-vis the escapement of income. There is a fine distinction between the two. There could be a dimming fiction or a presumption that yes, sir, there is an availability of information, that there is some escapement. But that availability of information resulting into escapement is to be decided by the AO on a case-to-case basis. The second presumption is that yes, the dimming fiction says that there is an escapement and therefore immediate remedial action. Now, department is following the second line of argument. That, sir, in such cases, we have the information which is suggestive of the fact that there is an escapement of income and therefore we will take remedial action. The SSCs are arguing that, sir, this dimming fiction, if you read it carefully, it only suggests that there is a presumption as regards availability of information. But that information alone is not sufficient. Information must suggest that there is an escapement of income. So therefore, that bridge, the nexus between availability of information resulting into escapement of income has to be built by the AO on a case-to-case basis. And therefore, there is going to be some action while interpreting those provisions. It is, if you want to look at the law on the issue, look at the original explanation 2 to 147. I have given a reference to that. And there the language of the law was very clear that explanation 2, it prescribed certain clauses which are presumed to be the clauses or situations where there is a dimmed escapement of income. And therefore, dimmed escapement of income is one part, dimmed availability of information is a second part, and that unless that bridge is built, that cannot be, department cannot on a presumptive basis issue notices left, right and center. Again, we have covered, there is no third party search related information covered under 148A3 that we have discussed. Procedure again, the procedure now is again standardized between clauses 1, 2 and 3. We are not spending much time on this procedure because most of you are aware that under subclause 1, there is a show cause notice. Subclause 2, you file the reply. And subclause 3, he passes an order wherein he says that yes, there is an escapement of income. And therefore, this supports the theory that whether the availability of information itself is sufficient or that information is only the beginning point suggestive of an escapement of income, and that suggestion to actual escapement has to be built or it has to be crossed in 148A1 to A3. The interesting issue could be that 148A 1 into bracket 148A1 is in the nature of show cause notice, and courts have now started taking the view across the country again that this show cause notice is the end result of inquiry and investigation, and therefore in 148A1 show cause notice you cannot ask for information, you cannot continue the inquiry. Show cause notice is culmination of all the inquiries and investigations into a final notice which is put before the SSA कि सर आपके हाथ में escapement है, अब आपको क्या बताना है. In that show cause notice, you can't ask for further information and carry on the investigation as if this is the beginning point. Again, that is supported by deletion of original 148A small a, clause small a, which was there between 21 to 24. That is the deletion thereof is a suggestive factor which is again going to be issued in favor of the SSA. 135A, that is again the collection of online information is outside the purview. We are for the time being skipping it. Effect of deletion of clause A to 148A of the Act, that is the issue which we have discussed so far. One more thing, the moment there is a notice under 148A, now the law says that every material, every information, everything is required to be given to the SSA. So supposing if 148A notice is issued to you, as a fallout of a search and material is not given to you, you can say that, sir, kindly give me the material. A third party search at a broker's place, a third party search at a builder's place. Whatever material which is there, which is the basis for the purpose of issuance of notice, you can ask for all those bases. The interesting or the finer question is that many a times people believe that this is the stage at which the moment material is given to me, I must also be getting an opportunity to verify the veracity of that material, or supposing a builder's statement is used against you, that he has said that I have sold flats and for every flat I have received 5 lakhs rupees in cash from the purchasers. Based on that, reopening takes place. You are given the copy of the statement. You say that, sir, at the 148A stage itself, I want to cross-examine the builder and I want to ask him that, sir, on which day I have given you 5 lakhs of rupees that you are talking about in the statement. Because I have never given you any money. I have taken 100% bank loan from my bank. These are the papers, and the remaining margin money I have given by way of a check. Where is the question of paying any cash? And therefore, I want to examine that person because his statement is running against me. Can it be done at 148A stage? We have a judgment of the court taking a view that such an exercise can be done. I have my own reservations that such an exercise can be done. Because even after the change in the language, namely from reason to believe to escapement of income, this is just a preliminary tentative or a primary stage. This is not a stage where a whole hog assessment is taking place. Therefore, you cannot ask the things which are otherwise subject matter of assessment proceedings. These are basically the proceedings for assumption of jurisdiction. Whether it's a fit case to be taken for reopening or no, it is at this stage that is the purpose of inquiry. The purpose of inquiry is not to determine the final tax liability. And therefore, asking for cross, etc. at this stage probably may not give you the good results. And it is at this stage only that you decide whether you want to challenge the action of the department by challenging the order under 148A3 read with 148 before the High Court, or for that matter, if you are extremely aggrieved, probably Supreme Court directly. But that is not to be done. You have to go before the High Court only on almost all the cases. At this stage, you decide whether the assumption of jurisdiction is correct or incorrect. That is the purpose of 148A3 order read with 148 notice. So this is the stage. Once you cross this stage, many high courts have taken a view that the moment you start participating in the assessment proceedings, आज 148A3 का order आ गया, 148 का notice भी आ गया, he gives you 142(1) notice asking for information. You are still confident कि वो नहीं आगे जाके समझ जाएगा, वो proceedings drop कर देगा. You participate, you give information. वो समझा नहीं for any reasons. So वो स्टेज पे इफ यू फील कि नहीं अभी मुझे जाके हाई कोर्ट में चैलेंज करना है क्योंकि ये मान नहीं रहा है, दैट इज नॉट द स्टेज. हाई कोर्ट माइट नॉट एंटरटेन योर पिटिशन ऑन द ग्राउंड दैट देयर इज एन एक्विजियंस, देयर इज अ tacit acceptance on your part. आपने एक बार jurisdiction में surrender कर दिया, assessment proceedings में participate कर दिया, then you can't go before the court of law and challenge कि सर अभी मुझे protection दीजिए. The second issue would be that at this stage 148A3 read with 148, do we file the return of income or we do not file the return of income? क्योंकि कई बार कोर्ट बोलती है कि सर आपने रिटर्न फाइल कर दिया, that means you have accepted the jurisdiction of the assessing officer. तो आपको क्या करना है? My personal advice is always file the return of income within a period of 3 months or whatever time that is granted to you. Because in case if you lose in the court of law, supposing आपकी writ petition खारिज हो गई, आप हार गए कोर्ट में, then you will be treated as someone who has not filed the return in response to notice under 148. And there is a provision for direct prosecution, and you would again be exposing yourself to a prosecution if the assessing officer is not very kind. So therefore, always file the return of income. In case if the revenue argues that, sir, filing the return of income is itself is an acceptance of the notice, you can always say that, sir, that return of income was filed, and immediately thereafter we have preferred the petition. In the petition you mention that return of income is filed. However, we challenge the assumption of jurisdiction, and that is how you can safeguard yourself. Courts have again consistently taken a view that filing of return is neither here nor there. It cannot be treated as acceptance of jurisdiction. 3 years, 3 months, and up to 5 years, 3 months is the existing scheme. Again, once the new act comes, 4 years, 3 months, and 6 years, 3 months. 1 more year would be added to this 149. Unlike the present scheme, which was introduced in 21, there was a safeguard provided in the form of first proviso to 149, wherein they said that time limit which has expired earlier would not be extended under the new scheme, because earlier 6 years, 21, 10 years, so 4 years were extended. There was a specific proviso which safeguarded the interest of the SSE to the effect that that additional 4 years would not be subject matter of reopening because that has already attained finality. Now that is not there in neither here nor under 25 Act. Therefore, this additional 1 year, what is going to be the scenario? Again, it's a gray area, but appreciate it from a slightly different angle. Here we are concerned with the scheme of assessment year read with previous year. Under 25 Act, which is going to be effective from 1st April 26, we are concerned with the tax year. Now tax year is equivalent to previous year, and therefore this additional 1 year, as per the argument of the revenue, is not an additional year. It is just to offset the preponement of the taxes. Today, previous year is over, assessment year begins, and your taxes are paid in the assessment year for previous year. So effectively you are running 1 year behind. With the concept of tax year, your income would be taxed in the same year, and therefore you are running 1 year ahead. And therefore, in order to compensate this, there is an increase against 3 years, 3 months, 4 years, 3 months, and 5 years, 6 years, 3 months. But then we need a full technical session to discuss the fallout of that. And then there is going to be an interesting issue as regards the income escaping assessment for assessment year vis-a-vis tax year. Again, I expect a lot of litigation once 1426 Act is pressed into service. For the first time, we also have now the limitation for 148A, and therefore the reopening beyond the period of 3 years is, again, these conditions are also valid for a third party search. So if the reopening is taking place beyond a period of 3 years from the end of the assessment year, then not only the availability of material, फाइनेंस ब्रोकर के यहाँ से कुछ मिला, उसमें से पता लगा कि आपकी 25 लाख की इनकम में आपने ट्रेड किया है और 25 लाख रुपए आपने कैश में दिए हैं या लिए हैं, एंड दोज matters beyond a period of 3 years cannot be touched because of 149 protection. That in case, even in case of a search, third party search, the material availability thereof, even acceptance thereof, would not give entitle the department additional period beyond a period of 3 years. So therefore 50 लाख से कम है तो 3 साल के अंदर ही रीओपन करना है. Even if search किसी के यहाँ होती है, मटेरियल मिलता है, 3 साल के बाद वो नहीं हो पाएगा, because 149 does not distinguish between a normal reopening case and a search reopening case. So these are all cumulative conditions, and unless and until the hurdle is crossed, there is no extension of any limitation. Now the enabling provision. Why did I say at the beginning that the searches which are taking place between 21 and 24 would continue to be governed by the present scheme and not by the new scheme? Because the law in India is otherwise well settled. Because these are all procedural law, the reopening, issuance of reopening notice and block notice, etc. And therefore the day on which assessing officer issues the notice, उस दिन का कायदा देखा जाएगा, चौपड़ी में क्या है, बुक के अंदर जो कायदा उस दिन लिखा है, that law would be picked up for the purpose of interpreting the law. Now this 152, 3 and 4 are an exception to that theory, that even if the notices are issued subsequently, if the searches, underlying searches have taken place between 21 and 24, then it will be continue to be governed by the erstwhile 147 scheme. And that would give rise to two interesting legal issues before I go to the practical issues. That 21 और 24 के बीच में सर्च हुई है, नोटिस इशू होती है अभी 25 में. नोटिस इशू होने के टाइम पे आपको पता है कि 151 पे स्पेसिफाइड अथॉरिटी के सैंक्शन is required to be obtained before the issuance of notice. Two stages. First, at the time of issuance of notice. Second is as and when you frame the assessment under 147, you have to obtain the approval of 148B, capital B of the additional commissioner. That is for the purpose of sanction of the commissioner while framing the order. मैं बात कर रहा हूँ नोटिस इशू करने के टाइम पे कौन सी सैंक्शन लेनी जरूरी है. Now the law says 152 subclause 3 says that the moment you say that search is between 21 and 24, you apply the old law. Old law between 21 and 24 had two separate limbs of 151. First limb was up to 3 years, commissioner, director, etc. Beyond 3 years, the principal commissioner, principal chief commissioner, director general, etc. After 1924, the law is amended. Now only one sanctioning authority, and that is a very lower level joint commissioner, additional commissioner, etc. But the 152(3) says that आपकी सर्च अगर ये दौरान हुई है तो आप पुराना कायदा लगाओगे. अगर पुराना कायदा लगाता हूं तो उसमें मुझे सैंक्शन लेनी पड़ेगी पुरानी अथॉरिटी की. So 151 clause 1 and 2 उसके हिसाब से मुझे सैंक्शन लेनी पड़ेगी. So that one legal issue which would arise is कि नोटिस आज की तारीख में हुई है इश्यू, आज की तारीख में सैंक्शनिंग अथॉरिटी जॉइंट एंड एडिशनल है, लेकिन कायदा लगाना है मुझे बिटवीन 21 एंड 24 वाला, तो उसमें मुझे लेनी सैंक्शन है कमिश्नर या प्रिंसिपल कमिश्नर की. अगर वो मैंने नहीं ली है तो ऑल दिस नोटिसेस वुड बी ट्रीटेड एज अ नोटिस विच इज इश्यूड विदाउट अथॉरिटी ऑफ लॉ. 151 पे अभी तो वी हैव जजमेंट ऑफ राजीव बंसल पैराग्राफ 76 विच सेज वेरी कैटेगरिकली कि ये एक जुरिस्डिक्शनल कंडीशन है. So if you have not complied with this jurisdictional condition, you don't assume jurisdiction. आपका exercise fail हो जाता है. So therefore this one interesting issue, again we have only admission orders of various courts, Allahabad, Delhi, etc. We do not have a final order on this issue. And second would be that 149 3 साल और 10 साल के बीच में है. अगर वो assumption of jurisdiction is vis-a-vis some years which are beyond a period of 3 years but before 10 years, then all those provisos which were existing prior to 24 insertion would continue to operate the field.
And therefore, whether those provisos are given effect to, those provisos are mainly for the purpose of protecting the interest of the SSC insofar as longer reopening leeway is given to the department. So whether those things can come to the rescue of the SSU or no, 153A, 153 read with the definition of relevant assessment year would extend the jurisdiction from 6 to 10 years, provided again only the asset in excess of 50 lakhs is revealed during the course of the search. Now, for the purpose of assumption of jurisdiction between 6 to 10, that proviso again can be pressed into service because you have to read the law as existing between 21 and 24. So again, that is going to be an interesting issue. And all these explanations which are appended to 148 and 148A would continue to apply. Now we come to the practical issues. After having discussed thus far, the issue which would arise would be, let me tie it with a real life situation so as to put across the points. There was this national level search by DGGI. DGGI is GST equivalent of investigation wing. So they raided insurance companies, mind you, all these big insurance companies, ICICI, HDFC, Reliance, all these big insurance companies were raided by DGGI on the ground, that by virtue of a scam, which was a national level scam having financial implications of more than 2,500 crore, these insurance companies were trying to give commission to their brokers in excess of IRDAI guidelines. Supposing IRDAI says that insurance premium में से आप 10% brokerage दे पाओगे, उससे ज़्यादा नहीं देना है. इनको देना है 25%. ये क्या करेंगे? बोलते they will appoint an intermediary. They would create some paper entities. Those intermediaries would bill the insurance companies for provision of marketing services, sales promotion expenses, these and that. Monies would be paid to these intermediaries. These intermediaries in turn would outsource these services from the very same brokers or someone who is nominated by those brokers. So एक कार का डीलर है, वो कार बेच रहा है आपको, वो बोला मैं आपके पास तो ही बिजनेस करूंगा, आप मुझे 25% कमीशन वापस दोगे तो. Everyone would have experienced this, that when they sell the car and if the car is in demand, they will charge you hefty insurance premium, and that premium is not at all equal to market price. The insurance company does not get the money. It's the broker who is selling the policy would get the money, and this is how money would be given back to him by creating false entities in between. DGGI issue arose because those entities were allegedly giving services to the insurance companies. The case was that these are only billing transaction and no actual services are rendered. And therefore they have raided. Most of the insurance companies confessed having entered into these transactions, their CFO statement, their account manager statement. The intermediaries also was searched, accepted that all this is bogus entry. Now the income tax fallout. Income tax fallout is very interesting. All those persons who have received this commission are now issued reopening notices. Across the country, we have thousands of notices issued. And the case is that you have received commission which is in excess of IRDAI guidelines. Therefore, we want to take remedial action in your hands. Most of the SSEs have answered that, sir, this commission is already offered as my income. Therefore, where is that fundamental condition of escapement of income being satisfied? Ultimately, escapement of income के ऊपर है. Income सही है या गलत है, उससे फर्क नहीं पड़ेगा. So long as I have offered that income for tax, there is no question of reopening. That is the first hurdle. Second, department, after hearing this, they came out with another argument. That, sir, we have two arguments against this. One is, though you have offered this income as a sales commission in your books of accounts, you are offering it as business income. According to us, this is nothing but a gratuitous payment. If it is a gratuitous payment, it has no business sanctity, then it is required to be added as income from other sources in your hands, and therefore there is no question of allowing any corresponding expenditure. Therefore, your profit and loss account, you have credit of commission, against that you have claimed large number of expenses. Now those expenses, we believe that you have wrongly claimed, and therefore we cannot allow you that. Therefore, the assumption of jurisdiction is correct. As of now, again, courts across the countries are seized of the matter. Most of the courts have accepted the argument that there is no escapement of income so long as I have offered it for tax. The reason I'll tell you why. Because all these notices were issued
148A3 read with 148A1, orders are passed on the ground that there is an escapement of insurance commission income. So long as that escapement is not there, there is no question of going beyond the notices, beyond the orders, and therefore courts have, as of now, accepted the cases of the SSE and granted stay in the matter. Second is again searches at a finance broker's place or a Hawala entry operator's place, and then the data containing the name of the SSE is found out. Look, what is the allegation? Let us understand that. A finance broker is someone who is taking money from X and giving it to Y, keeping some margin in between, and he gives an assurance that आपको पैसे में वापस लाके दूंगा. So this is basically a grey market money organizer who is borrowing from someone, giving it to someone, earning his commission, and we get an assurance that on the due date we will get our money back. Most of the time we don't get, but then again greed is always it suppresses the fear and overtakes in a situation like this. So we deal with that. Ultimately, the finance broker or the Hawala entry operator is searched from his premise. Some meticulous records miraculously is always found out. Some Excel sheet or some diary wherein everything is written to the minutest of the details. That ये पैसा यहाँ से आया, इसका नाम ये है, उसका पान नंबर ये है, वो इस दिन को आया, इसको दिया, इससे लिया, and this is the interest margin that I want. Now, if this information is available, obviously the department will say that, sir, you have some cash transactions. Either it is in the nature of earning of cash income or unexplained investment into granting of loans. So either it is income or 69 unexplained investment, or there are some credits which are in cash, so cash credit under section 68. All these would lead to ultimate escapement in the hands of the concerned person. Now, the issue is, at this stage, what is it? What is the argument? What is it that is one can find out? Look, if it's a pure and simple cash transaction, probably it is my words against the words of the broker. However, what can come to the rescue, and Jinesh bhai, તમે જે સવાલ લીધો એનો જવાબ, what can come to the rescue of the department is that there is a presumption under 132(4) read with 292, which says that any material which is found from a search person would be presumed to be correct. The contents thereof would be again presumed to be correct unless, again, it's a rebuttable presumption, unless proved to the contrary. Therefore, a broker's case is a subject matter of search. He has maintained some record. If he has maintained some record, that record is presumed to be correct. The contents of that record is again presumed to be correct. If that is there, if all this is correct, then obviously I am just a counterpart of those transactions. Therefore, that presumption would, whether I like it or no, would run to me as well. However, these are all rebuttable presumptions. As I said earlier, that what is the rebuttal at this stage that can be done, and that is, the rebuttal at this stage is that if it is a cash transaction, again, ultimate denial is at this stage may or may not be sufficient. If you deny that I have never into any such cash transaction, I have not given a single rupee to that finance broker, or I have never not taken a single rupee from that finance broker, and what is the proof? He can write anything. Again, you have a case, because the judgments of common cause read with V.C. Shukla, all those judgments ultimately lay down that the common cause was under the Income Tax Act itself, that unless there is some linkage which is found out between the two parties, the contents thereof would be presumed to be completely useless. So if it is a builder's case, wherein I have admittedly purchased a flat, then probably I cannot deny that, sir, I have got nothing to do with that builder, वो पागल है, वो कुछ भी लिखता है अपने डायरी में, मुझे उससे कुछ लेना देना नहीं है, वो argument नहीं चलेगा. But if it's a finance broker, where you admittedly do not have any recorded transaction, you can always say that, sir, I have never dealt with that person, and therefore there is no question of tying me with him, and therefore that is something which you can there cite all these judgments, all these lines of judgment, wherein you can say that, sir, there is an absence of transaction with that person. I would call it absence of live nexus with that person. In absence thereof, my defense is always, I have never dealt with that. Supposing there is a transaction, let us take the second example, builder's case.
I purchase a flat. 2 crore is the recorded consideration. 50 lakhs is unrecorded. Builder has some records wherein he says that yes, I have received 50 lakhs rupees from XYZ on the sale of flat number A103. Now, if that is the argument, then again, courts have taken a view, and that, mind you, not at the reopening stage. I'm going to the last leg of this discussion, that whether in the assessment proceedings this can be used or not. At the assessment stage, courts have taken a view and series of judgments that merely because builder has mentioned something in his diary, that by itself is not sufficient so as to make an addition in your hands. I'm not saying reopening is not justified. Look, reopening is justified. The moment you have a transaction with a builder and the builder says that yes, I have accepted some cash from this person, reopening is justified. However, whether that tentative initial belief or initial proof, can it be used as a final proof for the purpose of making the addition? Answer is no, because we have judgments of various courts across the country taking a view that no, that by itself is not sufficient and that cannot be used for the purpose of confirming the addition. Estate broker, we have a curious case of, large number of estate brokers are there. They are basically gathering information from various sources. They make a client inquiry register. That client inquiry register is, supposing today I want to sell some land. I tell my broker that, sir, I want to sell this land at X price. So he would then put that message into his broker community. So large number of other brokers would be privy to that information that yes, there is a land at so-and-so places, asking price is so-and-so, anyone is interested, contact this broker. So now all this information again collectively would be placed into some client inquiry register. That register is subject matter of search and collected during the search. Whether that by itself would give rise to any escapement of income, again here the first principle would come to your rescue. So long as that concerned broker is not a broker in a transaction, then there is no adverse presumption which can be drawn, because I can always say that, sir, that I do not even know that broker, I have never dealt with that broker, this transaction is directly with the buyer and seller, and therefore there is no question of any intermediaries. So therefore you cannot take or use this material as something for the purpose of assumption of jurisdiction. And therefore, as they say, that it is only the availability of material which can be questioned by the court. Sufficiency of the material can never be questioned by the court at this stage. Therefore, I'll say that, sir, there is no availability of material because I have not dealt with that broker and therefore I can get away. STR based reopening, probably not the flavor of the day because we are discussing search related issues. Therefore, I'll skip that. Sanction I have already covered. One technical issue, again, Jao Fao, even in case of a third party search, this issue is live, kicking, pending before the Supreme Court. We have, judgments across the country. Some high courts have taken a view that it is permissible, like Delhi High Court. Some high courts have taken a view that it is only the faceless authority which has the jurisdiction. Jao has jurisdictional licensing officer has no authority to issue any notices post 29/3/22. And therefore, that issue is alive and kicking. There, even the search cases are also included. So, cases which are centralized and the jurisdiction is assumed by the central circle, even those cases are also covered by this circular, and the courts have taken a view that this the assumption of jurisdiction by JO is not correct. So, as and when we reach to this stage, probably we will know, depending upon the High Court's view, you can use this for the purpose of challenging the action. In the Gujarat, at least, we are not getting any interim relief on the basis of Jao Fao argument. The judgments I have narrated, we are skipping those judgments. International and search, tax and search cases are also covered by this controversy. Only NFSC has the jurisdiction to issue the notices post 2022. That would take me to the second limb, that is 158 BD, undisclosed income of any other person. So, undisclosed income of any other person, this is specifically a provision which would come into play for all the searches post 1924. So, any search has taken place after 1924, the action could be taken under 158 BD, provided, of course, in the hands of the search person, there must be some material which is either belonging to or pertaining to or relating to. I have highlighted those words. Belong to, pertain to, relate to third party. And if that money, bullion, jewelry, valuable articles, documents or any evidence is pertaining to, relating to or belonging to a third person, then 158 BD action can be taken. Now 158 BD action, if the moment it is taken, it exposes you for a period, for the entire block period. Because earlier the argument, one of the argument was that 153C, whether it is for 6 years or only for those years where some material is found. Now here again we are back to block assessment scheme. And therefore for any of the year falling within the block, any material is found out, then entire block gets reopened. Again 158 BD is only for undisclosed income, but then there is going to be one issue which is raised by Jinesh Bhai, which we will discuss in a couple of slides from now. And the 6 years preceding the previous year in which search takes place. Now the practical issue. The 6 years versus only those years where material is found in search. I have already answered that this is going to be a item for 6 years. But then what about the assessment of those 6 years? Because those 6 years assessment would take place because the notices are issued. Now would it be determined at 0 or he can go into any other income which may come to his notice during the course of the assessment proceedings? If you compare the language of 158 BD of the erstwhile act between 95 and 2003, and if you compare the language of 158 BD of now, you would find now we have the words any other material or information as are either available with the assessing officer, that is pre-search available, or come to his notice during the course of the proceedings under this chapter. So anything which is already available, that is a first part of the information, because these are the material which is going to be used for the purpose of framing the assessment. Second bunch of that information would be anything which comes to his notice during the course of the proceedings under this chapter. And therefore, that issue which was raised by Jinesh Bhai, that whether any material can be used by the assessing officer or it is only restricted to the block assessment, 158 BB subsection 2 has some answers that it would be any material which is coming to his notice. But then also, kindly mark the and in between. Now, this any other material or information as are either available with the assessing officer or coming to his notice during the course of the proceedings under this chapter. What does it indicate? It indicates that assessing officer, even information which is available during post-search inquiry can be privy to that information and can be used as a basis for the purpose of making the assessment. So original search, there is some hundis, there are some promissory notes which are found out. During the course of the cross-examination, further information is found out, and that information is that I am the ultimate beneficiary of those hundis. Now whether that information, post-search statements and post-search material, can it be used? Answer appears to be that yes, it can be used. And therefore, the fundamental argument that whether undisclosed income post-block search assessment is restricted to only undisclosed income or undisclosed income would also include the regular income and vice versa. Therefore, this again is an issue which is going to be a hotly contested issue wherein both the sides would try to argue that it is a specific assessment and therefore only undisclosed income, and revenue would say that, sir, because of the peculiar language of 158 BB2, we would also incorporate post-search material which is available with us. Degree of proof is again going to be another angle wherein one would say that, sir, what kind of degree of proof is required? Whether it is degree of proof vis-a-vis the search material which is found, or degree of proof is insofar as the submission, the statements of the parties are concerned, can alone be taken as some amount of evidence, and that is sufficient for the purpose of making the addition. Natural justice, cross, etc. is much discussed, and therefore you all know that we can ask for all the material, search material, counter it, cross, etc. Extrapolation estimation is not permissible. Again, we have series of judgments under the old block scheme under 153A itself, that if the material is found only for 1 year, and then assessing officer is issuing a notice 158 BD for entire block period, and while framing the block period, he would say that, sir, in 1 year if you have done some illegality, we'll presume that remaining 5 years also you have done the same illegality in the same proportion, and therefore we'll estimate your income. Now that is not permissible. 147 versus 148 BD, this is one issue where again the answer is that 158 BD is almost similar to 153C read with 158 BD of the erstwhile act. Basically, it is for the purpose of assumption of jurisdiction insofar as third parties are concerned whose material is found during the course of a person's search. And that material must be belonging to, relating to, or pertaining to the concerned SSC. Now the question would arise that, sir, can we go for 147? Because we are holding that 158 BD, we do not want to exercise at this stage. We want to exercise the jurisdiction under 147. And therefore, we are taking action against 147. At that stage, is it open to the SSC to challenge that, no, sir, because this is a search material, you have to only apply the provisions of 153C and or 158 BD. Again, this question is answered by series of high courts, Rajasthan in favor, that it so long as it is material which is found from a search, the only remedy available to you is 158 BD or 153C. These are all judgments in response to 153C versus 147 controversy. However, these are all equally useful for the purpose of the present controversy, that is 158 BD versus 147. Again, why such a argument? Because what is the sanctity of this argument? 158 BD would expose you for 6 years. Why do you want to go under 158 BD when assessing officer or assessing authority is only issuing notice for 147? The answer could be that 147 is a reassessment where all additions are at large. Whereas 158 BD, probably you can say that, sir, whatever material that is found, you can't exceed that material and you can't go beyond that. That is probably because under 153C, that law was well settled. Now under 158 BD, probably we'll see the development of law over a period of time. And then one would find out whether this argument is worth taking or not. Green are all in favor, red are against. Regular assessment, I have briefly touched this aspect during the course of the discussion earlier presentation, that if your assessment is live, it is going on today, namely there is no remedial action. The regular assessment itself is today going on, and if during that a third party search material is brought into the books of the assessing officer on the portal of inside portal of the assessing authority, that GST search, bogus billing, all that information is available. You have made huge purchases from that party, whether that can straightway be disallowed or no. Again, every situation would give rise to a different defense. But there are common things. Let's say the example which I gave you, that GST department, bogus billing, purchases are found to be bogus, show cause notice. My answer is that purchases are genuine because the sales is not questioned. And therefore, you look at my quantity data, you look at my sales, I have already offered it. Assuming that you do not agree, maybe some percentage disallowance as held by various courts across the country, either based on the certain percentages of the purchases or reject the books, estimate GP, NP, etc. based on my last 3 years performance. But then you have a right to copy of the complete material, whatever evidences which are there, you have a right to examine those evidences. In a case of GST, then the GST statements, you can always say that, sir, these are GST statements given under a different circumstance. Assessing authority, the law says that for the purpose of initiating the inquiry, yes, he can rely on GST investigation, but not for the purpose of making the final addition. For the purpose of final addition, he has to carry out his own investigation. So has he called that supplier for the purpose of investigating him? Has he examined him himself, or AO is only relying on the GST material? These are all the issues which would arise during the course of the regular assessment proceedings. Right to statement, need to cross-examine. Again, the cross-examination is a very, very dangerous weapon. I would say that it is like weapons of mass destruction. वो ट्रंप दिखाता है ना कि हमारे पास एटॉमिक बॉम्ब है, वो कभी फोड़ने वाला नहीं है. That is only for the purpose of scaring people. It is only to maintain the world order that we have this kind of weapons. Cross is one such weapon which is only to be shown, rarely to be used. Don't use the cross unless you are sure that the person who is coming for the statement or cross-examination is going to say something in your favor. If he utters something which is against you, then cross would be the biggest evidence in favor of the department. Supposing आप बिल्डर के पास में बोलते हो मैंने पैसे नहीं दिए, ऐसा करके कर रहे, बिल्डर आके बोलता है नहीं नहीं आपने पैसे दिए हैं, ये प्रूफ है, ये सीसीटीवी फुटेज है, उस दिन आप आए थे, लाल शर्ट पहन के बैग लेके वो कैश दे गए, then you are gone. So therefore cross is a defense, a submission which is to be used but not to be exercised. Electronic communication and 65B of the Evidence Act, because Jinesh Bhai raised this issue as well, that what is the sanctity of this. Look, electronic communication is the biggest culprit as of now, because people chat whatnot on the WhatsApp, including the financial affairs. Either it is WhatsApp, many a times people download some peculiar apps, some Chinese app, thinking that no one can break it, no one would realize that we have communicated on this app, and they would, print a huge amount of digital footprint, which is always accessible. So anything on the world, anything on the digital www, that is the World Wide Web, is never going to go away. It is always there. So, however, what is more significant is that what is the sanctity of a third-party search digital evidence? What you can do is, you can ask for the procedure which is prescribed under 65B. The procedure is that it has to be certified to be the correct digital record. आज मैं फ़ोन उठा के समीर भाई के नाम पे PM मोदी लिख दूंगा एंड कम्युनिकेशन करूंगा, तो वो PM मोदी के साथ नहीं माना जाएगा. मेरे मोबाइल में वो PM मोदी दिखाएगा, communication दिखाएगा, but that by itself is not sufficient. What is required to be done is, you have to, based on the number which is there against the name and the number of the recipient, you have to compare those two numbers, go to the TRAI, find out who is the legal owner of those two telephone numbers, go to WhatsApp, from the server, take a report from the server of the WhatsApp that these are the communications which are real, which have taken place. And if that is certified, then only it is admissible as an evidence under the Evidence Act. Unless you do this, that cannot be simply used. So many a times if department is reproducing a lengthy chat between the two persons and saying that based on this, I add X, Y, Z, that is not permissible. You will have to, at appropriate time, you will have to ask for this 65B evidence procedure. And for that, you have to refer the matter to a forensic lab. That process is there and you have to follow that process. Unless that is done, you can't simply use electronic communication as an evidence in any of the fiscal statutes. Certain live issues, finance broker, we have already discussed. Accommodation entry, we have discussed. Bogus purchase, bogus sale, bogus share capital, GST fake invoice and penny stock. Probably we have briefly touched on all these aspects. So I'm not going further into this. Again, I have given one example where what all can be demanded. This again is for the assessment proceedings. So complete data, exact number of entry, degree of proof, that is to what extent this is believable. If, as Jinesh Bhai in the opening remarks said that if there is a check entry and cash entry appearing simultaneously on the same piece of paper, then again you will have a larger explanation to do, because then the presumption runs against you that if part of the document is correct, courts have taken a view that documents are required to be read as a whole. So you cannot ignore one part saying that this part is correct, but the lower part I do not know. वो पागल है, उसने कुछ लिख दिया है, लेकिन ऐसा नहीं चलता है. Dumb document argument, let me at this stage touch that. I have seen that people take this argument very casually. ये dumb document है. Dumb document मतलब पता नहीं है किसने क्या लिखा है, मुझे कुछ लेने देना नहीं है, मुझे छोड़ दीजिए. Most of the times when someone sitting on the other side of the table, namely the judges, they are not very kind to this argument. वो इसको मानेंगे नहीं. Unless you have some more material, that dumb document argument is not going to win you the cases. Maybe at some stage you can influence the commissioner, etc., and get a favorable order. But moment you go higher up and someone decides the matter on merits, dumb document argument, unless it is proved absolutely to the hilt that this is genuinely a dumb document, there is no underlying commercial transaction, that argument is not going to win you the cases. Builder on money, we have covered. Estate broker, money bullion, valuable article, etc. Everything in writing, know your facts, don't offer more than what is asked for. Probably we can skip this because we are almost running out of time. Yes, requisition. Requisition में क्या होता है? कोई भी थर्ड पार्टी सर्च होती है, वहाँ जैसे GST सर्च भी होती है. GST के अंदर सर्च के अंदर they cannot seize cash. As per the law which is settled and language of the statute is also clear. Any other material लिखा है जो सर्च के statute में, उसमें cash covered नहीं होती है. So cash मिलती है उनको. They cannot seize that cash technically. Therefore, they'll have to compulsorily hand over the cash to the income tax department. So they call the income tax department. उनको बोलते हैं कि सर ये 132A में requisition में ले लीजिए. Now, once it is coming into the possession of the income tax department under 132A, all other provisions would follow. Now, ऐसे पुलिस को मिलता है पैसा. That also goes to income tax department under 132A. CIFS, आप एयरपोर्ट पे 1 किलो गोल्ड के ज्वेलरी लेके जा रहे हैं, and if you do not have proper proof, bills, etc., they might call income tax department, hand over the material to them. So what is the procedure? Procedure is the moment any such requisition happens, the first thing that you must do is write a letter requesting for the release of the material along with complete explanation, along with documentary evidences to both the persons. A, your assessing officer, and B, the person who is seized of your ornaments. Supposing आप अहमदाबाद के हैं, कैलकाटा में आपका एयरपोर्ट पे ये ornaments मिले हैं, then Calcutta investigation wing is seized of the matter. You have to address letter to both your AO as well as to Calcutta authority, along with a request within a period of 30 days from the end of the month in which requisition takes place. Request A and B all documentary evidences to submit to the satisfaction of the authority that whatever that is seized, whatever that is requisition is duly explained in the books of accounts. Then the third proviso of 132B says that it has to be then processed within a period of 120 days, again to be counted from the date of requisition. So अगर आप 30 दिन के अंदर देते हो उसको, 30 दिन from the end of the month in which the requisition takes place. So आज requisition होती है, आज 9 तारीख है, तो 30th November से 1 महीना. So you have a time till 31st of December. If that happens, then 4 months to be counted from today, requisition के date से, the revenue has to then either accept, reject, or partly accepting, partly rejecting your application and pass an appropriate order. If they do not do it, then there is a deemed release in your favor. These are the judgments wherein courts have accepted this argument that within 120 days period, if there is no adjudication by the authorities, it has to be compulsorily released. And if you are extremely unlucky and there is a consequential search, थर्ड पार्टी सर्च हुई, बहुत बिल्डर के यहाँ सर्च हुई, उसको पता लगा कि ये जेडीए किया है और जेडीए के अंदर लैंड ओनर है, उसने पूरी लैंड दी है, एंड दैट लैंड इज कॉस्टिंग few 100 crore and that also there is underlying cash transaction. So then they will immediately go and search the land owners as well. That is a consequential search. So consequential search आती है, उसमें क्या what are the precautions that one could take? You can challenge the search, reason to believe, आप उसको चैलेंज करके बता सकते हैं कि where are the reasons to believe, because usually वो reasons to believe थोड़े जल्दी में लिखे जाते हैं क्योंकि consequential search है और उसमें कहीं loopholes होते हैं. So you challenge, the law is well settled again, success rate is less than 1% in case if you challenge the search. So therefore you can take your chances, and question the reason to believe of carrying out of that search. What is reason to believe? Again, explained by the court, something which is well known. I'll not spend much time on that. Then again, you can then go to the judgment, because the reason why I cited this judgment is it's a very welcome deviation from the law that I have grown up learning. The law which I have grown up learning is that there is no sanctity in challenging the search, because even if you succeed, search chali gayi, then also any material which is collected in an illegal search can be used as an evidence in framing the assessment. That is Puranmal's judgment right from 90 ITR. That is what I learned all throughout my student year as well as during my practice years. This is a welcome deviation from that. 2024, this is a judgment wherein the court has analyzed the concept of illegality versus unconstitutionality. So courts have put both this illegality and unconstitutionality on a different pedestal. Court said that any illegal search, you are right, Puranmal would continue to hold the field. However, if the search is unconstitutional, then you can't touch it, because then it gives rise to the fruits of a poisonous tree. So any assessment which is framed post unconstitutional search is completely illegal. And why do the court has deviated? Why has the court deviated? Court has said that, sir, the proof of unconstitutionality is Puttu Swami's judgment. Putta Swami's judgment was a judgment where someone said that I don't want Aadhaar, because Aadhaar infringes my privacy. And right to privacy is a fundamental right. Constitutional bench of the Supreme Court said that you are right. Apart from the fact that one of the issues of this very matter is before, again, a larger bench of 9 judges, whether this kind of Aadhaar amendment can be introduced in the parliament by way of a finance bill or no, that is a subject matter which is pending. But Putta Swami says that right to privacy is a fundamental right, and therefore any search by any income tax authority is a violation of your fundamental right. Now that violation, if it is not as per the guidelines put by the Putta Swami's case, it is unconstitutional. And therefore the guidelines of the Putta Swami's case is the doctrine of proportionality, the last bullet. Doctrine of proportionality is, आप गए हैं undisclosed income find out करने के लिए. So undisclosed income find out करने के लिए आपने किसी की मदर को रूम में बंद कर दिया, किसी को मेडिकल नीड है वो नहीं दी, आपने अनकनेक्टेड लोगों के फोन ले लिए. माई कॉलेज गोइंग डॉटर, हर फोन वुड कंटेन सो मेनी थिंग्स विच इज नॉट ओपन टू द वर्ल्ड. उन्होंने वो ले लिया, उसका कॉपी कर दिया, मेडिकल एडवाइस आपको रिलीफ नहीं दी, एंड सीसीटीवी फुटेज बंद कर दिया जाते ही. दैट्स अ स्टैंडर्ड प्रैक्टिस. दे ऑलवेज switch off the CCTV footage. Their argument in the court is, because once we challenged the search, and we also argued the same thing, their reply affidavit, the revenue's reply affidavit said that, sir, we switch off the CCTV footage is because they, by sign language, they can tell someone sitting remotely to delete everything available on the cloud. And therefore, we switch off the CCTV so that they cannot communicate with anyone who is privy to the feed of that CCTV footage. But that's an argument which is, again, completely without any basis. But these are the guidelines. And therefore, court said that if you act in a manner, you are not going there to arrest a terrorist. These are the tax-paying citizens of the country, and therefore, if you violate the fundamental right, it is an unconstitutional search. If it is an unconstitutional search, Puranmal cannot come to your rescue. You can't then frame 153A assessment, etc. And now that is supported, even the court says that in absence of any incriminating material, abhisar, etc., and ultimately assessments are also directed to be cost. Matter is pending before the Supreme Court. SLP is admitted at the instance of the revenue. But this is again a welcome deviation insofar as challenge to the search jurisdiction is concerned. With this, friends, I'm over. My presentation is over. I can now take questions, and subject to what Chairman has to say, we can forward the session.
Yeah, you have it.
Sir, we extend our heartfelt thanks to Tushar Hemani sir for his insightful and meaningful deliberation on today's topic. Before going to question and session answer, we invite our chairman, Sri Jignesh Banjara sir, to kindly share his concluding remarks on this session. Thereafter, we have taken the question and answer session. Then we start with the question and answer session.
After this wonderful deliberation by Tushar Bhai, all the way is flown from Ahmedabad, conclude करने का सर क्या रहता है जब आप पूरा innings आपने खेल दिया? So there were a lot of issues and there are a lot of issues, of course. You know, sir, on 147 you said any item third party में addition कर सकता है. 147 we all know जब reopen हो गया किसी थर्ड पार्टी का इंफॉर्मेशन में मेरा केस एंड आई एम ओपन टू फुल स्क्रूटिनी बट आई थिंक अंडर 153C दैट इज नॉट सो देयर इज अ लिटिल डिफरेंस इन सो फार एज 153C इवन फॉर 158BD अभी तो नए में पूरा ब्लॉक खुलेगा सर अनएबेटेड ईयर्स में आई स्टिल थिंक इट कैन नॉट बी डन इवन डायरेक्ट पार्टी का भी और थर्ड पार्टी का भी बट देयर इट इज ओपन फॉर द एबेटेड ईयर्स लास्ट 2 years एंड विच इज wrong in the new law, even in so far as the direct search parties are concerned, not only to third parties. And sir, 158BD में आपने 158BB2, which is now 293, 4, 5 something. Any material which comes to the notice of the AO, you said. I think any material, मतलब आजकल जो इन लोग को informations prior to search case में आती है, I think they are referring to that. किसी third party का खुल गया doesn't mean कि उसके PL balance sheet खोल के he can carry on with that. Any material, I think it is restricted to that. Otherwise, तो ये Pandora's box है, sir. One more thing I would like to, जो मैंने opening में भी I had posed this. You had also mentioned this VC Shukla case and in all these cases, we all have a habit of putting in our arguments. थोड़ा सा I would like you to touch on this VC Shukla, Sahara, Jain Hawala. ये सब criminal cases के लिए बोला गया था. What would be its impact when we are litigating our fiscal cases, income tax? And then I think we can have queries from the floor.
Look, VC Shukla was, again, as you rightly said, it was a CBI case. And therefore, there, the only defense is the reasonable doubt. Because criminal prosecution proceeds on the reasonable doubt principle. Whereas in a fiscal statutes, we all know, right from Sumati Devi Dayal, etc., that there is always an element of preponderance of probability. And the court would always swayed by the fact that whether this is humanly possible or not possible. And therefore, here, it's not the reasonable doubt. It is usually the reasonable doubt which is always held in favor of the revenue. And therefore, it is not expected that when there is an underlying cash transaction, you must prove with the photograph, CCTV footage that this was the person who was going there with a bag full of cash. Even the notings are sufficient so as to make the addition. Having said that, the fundamental line of distinction, which I also touched briefly upon when I was delivering the lecture, is that the privity of the connection between the two parties. So if supposing tomorrow Jinesh Bhai writes that I have given 1 crore rupee to Tushar Hemani, then if he is searched and if that material is found out, then I can always take the defense that, sir, this kind of pieces of paper are completely useless. And that is what has been done in the common cause. Common cause was an income tax matter wherein Sahara was searched. Sahara and Birlas were searched. During the Birlas and Sahara search, there was an Excel sheet which was found out wherein certain politically higher-ups names were mentioned. And there was an amount which was mentioned. The accountant was cross-examined. He said that, sir, we have given this money for the political funding of this political party and this was the money which is actually given. Based on that, a PIL came to be filed under Article 32 directly before the Supreme Court on the ground that you advise some action based on this. And their Supreme Court said that all those people who are politically higher-ups, their name can appear anywhere and you can't take cognizance of the same. Same way, if my name appears in anyone's diary and if there is no connection whatsoever, and if I can establish that I don't even know that person or I have no financial transaction with that person, I can still succeed with that argument that, sir, you cannot write anything unless you want something more. So a secondary evidence is required. What is that secondary evidence? We do not know today. It could be a statement of the person, it could be an affidavit of the person, it could be a third party eyewitness, or it could be a third party intermediary. Unless a secondary evidence is brought, that the entry by itself cannot be used for the purpose of making any addition, and we have judgments to that effect following common cause judgment under the income tax law as well. Insofar as that unabated year, your argument is 153C, yes, the law is well settled, that we have judgments of the court saying that this is a search-induced assessment, and therefore in the search-induced assessment only search items, no regular assessment items. However, government has learned from it, and they have now enacted the act, which is, to say the least, very ambiguous. And therefore, I hope Jignesh Bhai's representation is accepted, and government comes out with some amendment. As long as the law which is there, 158BD read with 158BB and 2025 Act, as long as the law as it stands today, it is subject to interpretation, and that interpretation has to be done by some high court someday when the matter is ripe. Unless that happens, we are living in an era which is, I would say, a bonanza for the professionals and a nightmare for the SSEs.
Thank you. So I think we can have some.
There is a question, the cabinet slide from the example given by you. A property is purchased for 2 crores from a builder, and a search is conducted at the premises of the builder, where a WhatsApp image is found, which shows that I have purchased, which shows that I have given by check number such and such, dated such and such, from State Bank of India, 5 lakh rupees, check number such and such, 5 lakh rupees, cash rupees 2 CR. Now my purchase is for 2 CR. The document that has been found, when I confronted this document with the department, they say that the check, I said that the checks are false. The document which is found is true or false. I have proved that the checks given are nowhere found in the memorandum of consideration in the deed. I have not paid such checks. So the document is false. But the argument of the department is that the checks might have been destroyed and you might have given 2 crores as cash. How do we address that?
Look, you have a better case, because if you believe that those checks, the numbers of the checks which are written in the WhatsApp chat, if they are not found to be actually encashed, there is no transaction, underlying transaction, then you can always say that these were all the negotiations which was taking place. Yes, you can always say that this was a negotiation, which was a preliminary discussion, which we were to give all this information, check, etc. Ultimately, it did not materialize based on these terms, and the final terms are like this. And that is how you can. But then, look, this is a material which is again would not save you from reopening action. You have to undergo the assessment. During assessment, you can always say, and assuming that there is some material which is available with the builder, then also you can say that we need certain additional material, and we have court judgments to that effect, that the chat alone cannot be used for the purpose of making the addition.
You know,
right.
Yeah. No,
but
so
it is
then,
never encashed.
No,
Look,
it is,
I can issue the check. But there is
some amount has been debited to me.
no.
the
He's saying that
department.
those checks which are
Check
there.
is not encashed, then some amount is debited in the books of the person who has issued those checks.
That
So
amount
is
is
the evidence.
that
No,
amount
these
is by
days-
way of another check.
No, but these days, madam, banks don't debit. But what the department will have a good case, I feel, if the check series is matching with the checkbook which has been issued
That
to
is
the
what I
SSE.
am saying.
Now let me answer that.
And,
Let me answer
and,
that.
and if
Yes,
the
yes.
2 checks are cancelled, they are
Assuming
not-
that the series matches, then also look, privity of contract is not denied by anyone. This at best establishes the privity of contract. कि आपकी सीरीज से ही चेकबुक उन्होंने फ्लैट खरीदा है, that itself is not in doubt. What is in doubt it is under what terms and condition. Now terms and condition are usually narrated in the MOU. Now that MOU is substantiated by some additional evidences. उसमें उनके चेक पाए गए जिसमें से ये बोल रहे हैं कि एक भी चेक डेबिट नहीं हुआ है. एक भी चेक अगर डेबिट नहीं हुआ है, then you can say that this is a failed negotiation. If it is a failed negotiation, you can't pick up the consideration from that failed negotiations. We have judgments to that effect.
That in the builders, I can say that on one sheet, it is written that 5 lakh has been given by this person by way of this check.
Right.
And another 5 lakh is given by virtue of this check. So
Right.
he has 2 entries regarding those checks. This person is saying that I have not issued these checks to the builder.
No.
If
He is saying
those
that the
checks-
checks which are issued are never encashed by the builder. That is what he is saying. So anyways, look, that the issue is, we can have difference of opinion and ultimately the court will decide.
Yeah.
But this the issue, simple issue is it can be argued like this because ultimately you are caught. Now you have only 2 options, either to contest the matter or surrender and pay the taxes. If you want to contest, you can use my argument. If you want to surrender, you can use anybody's argument.
You said about the crossfire of income tax in respect of GST inquiries. What about the converse way around?
Yes, it can happen. In a given case, income tax search, supposing take an example of an income tax search where undisclosed turnover is found out. I am very happy to offer 1% on that undisclosed turnover because take an example of a scrap dealer, huge undisclosed turnover. He says that sir मेरा मार्जिन ही 1% है, मैं 1% भर देता हूँ, मुझे छोड़ दीजिए, 100 करोड़ के ऊपर 1 करोड़ भर देता हूँ, लेकिन 100 करोड़ के ऊपर 18 करोड़ वहाँ भरना है. So therefore, whether that is permissible or not, that is equally permissible. Therefore, what has to be done is that when you are caught with an undisclosed turnover in the income tax search, the statement should reflect that I am not sure whether this additional income that I am offering is on account of undisclosed turnover. What I am offering is there are discrepancies in the books of accounts. In order to buy peace of mind, I am offering additional 1%, additional 1 crore rupees undisclosed income. I don't say that this is on account of 100 crore of undisclosed turnover. So you have to take care during the course of recording of the statement during the income tax proceeding itself. If you very categorically say that sir this is on account of undisclosed turnover and therefore and that in the next caveat what you can say is any discrepancy in so far as turnover, expenditure, purchases are concerned, those are presumed to be covered against this disclosure and grant me the set off against this disclosure at a later stage if any such discrepancy is found out. That would save you from any consequential action in the GSTs.
And these days, all this data is shared on
Sir.
REIC platform, Regional Economic Intelligence Committee. So it is better what he said. There should always be, such language should be used to buy peace of mind.
I
Sir,
have always heard Sumati Dayal being used against the SSC. Can Sumati Dayal in a particular situation be used in favor of the SSC? Exactly where in a situation
Can
where
be.
you, on certain apprehension, you carry out, there is a notice for investigation cell, they collect information, thereafter there is a search and you do not find anything in search. So I am trying to build up that Sumati Dayal is in my favor there.
Absolutely.
That if your allegation was cash deposited in bank, whether my cash, somebody else's cash, stocks, subsequently no stocks found, no difference in cash, nothing found at all. So I'm trying to say that Sumati Dayal in this case should be in my favor.
You can.
So probably it could be.
If you succeed before the court, kindly share the judgment with us. So we'll also get enlightened.
Yeah, this is what.
sir, I have a very simple question and very practical question. Search has been completed during April 21 to August 24. My question is, when the issue of notice for assessment or reassessment will get barred by limitation? This is my question.
Reassessment, you will have to go with 149.
Sir,
149, whatever is the concern assessment here. Look, during 21 search or 22, let's assume that search takes place in 22. So 22 search would expose you for, let's say 5 earlier years. So if it exposes you for 5 earlier years, then you will have to compute the limitation as per 149 based on the day on which the notices are sought to be issued.
sir, I would like to know just the exact date on which date it will get time barred.
You will have to compute from the end of the relevant assessment year, 5 years and 3 months and 3 years and 3 months. These are the 2 slabs as per the existing scheme of the Act under 149. So you will have to compute this from the end of the relevant assessment year and find out the limitation period.
Tushar sir, just one query. In 148A,
it was earlier A, B, C, D, now it is 1, 2, 3. Do you think that after this transformation from A, B, C, D, the power of AO has been restricted? Because whenever we approach the AO against the fresh notices under 148A1, they say, अगर B का नोटिस होता तो मैं D में आपका बात मान लेता, otherwise 1 में हमारा power restricted हो गया. What is your view on this particularly?
Look, the power is truncated this wise. Earlier, it was inquiry, investigation, show cause, reply and order. Now it is show cause, reply and order. Inquiry and investigation is taken out. It was earlier under 148A small a. Now that inquiry and investigation is taken out, and that is already available under 131, 133.
But he has to apply his mind,
yes,
at least.
Yes. So therefore now show cause, reply and order. Order, he can always drop the proceedings if he wants to.
You know, one more question for me. This one more is very good. I think this should be.
Yes. Right. Certainly, it is. In fact, it is. It's a conversion of a Supreme Court judgment into a statutory provision. You are right. If it is notice is issued and if you are prevented, supposing let's say he says that today he issues the notice and within 2 days he passes the order without giving you practically any time, then you can straight away challenge it, court would set it aside and put you back to the hearing stage. That is permissible.
Last question.
Thank you.
This will be the last question, please, of this session. Then we can have personal.
Actually, whatever the question put by Mr. Jani in the income tax, as our speaker says that if there is a bogus transactions and you have suggested to disclose 1%, but don't give that it is related to that transactions. So whether the income tax has got the liberty, because that 1% is not related to any transactions. It's a voluntarily whatever it disclosed. So whether the department has got the additional, because what I have suffered in that way, so whether the department can have the additional addition, because that transaction is not touched.
I also said, I understood your question.
Because there will be a double jeopardy.
That yes. Firstly, my 1 crore they will eat, and then they will say that now what about this undisclosed turnover?
Right.
You also disclose something on that account.
So I will be in the double jeopardy.
That's why I said, in the same breath, I also said that you have to then also clarify that in case of any further discrepancy on account of turnover, expenditure, purchases, if you make any addition, kindly grant me the set-off against my disclosure.
Sir, whether it can be adjusted, because once you say that it is, I am not connected to that transactions.
No,
because we are taking the two stands.
No, I'm saying that the disclosure has to be that there are certain errors in my books of accounts. And in order to cover those errors, I am disclosing 1 crore rupee lump sum without assigning any reasons, any breakup.
No, not to the any transactions also.
No, any transaction. In the second part, I say that, sir, at a later stage during the course of the assessment proceedings, if you find any discrepancy with respect to turnover, purchases, expenditure, then kindly allow the set-off of this 1 crore against that discrepancy. That's how I'll put it.
So that is the one advance tax.
Yes, it is.
It is a kind of advance.
It is kind of.
Right. Thank you.
Thank you so much. And we once again thanks to our eminent speaker and chairman, sir. Now I would like to invite to Pradeep Agrawal ji to offer a formal vote of thanks to this session. And please, thereafter some important announcement has been done by our Shyam Agrawal. So please wait.
Good afternoon. मैं AIFTP के तरफ से मैं AIFTP के तरफ से सभी का धन्यवाद करता हूं। साथ में मैं बंजारा साहब का भी शुक्रिया अदा करता हूं कि इन्होंने अपना वैल्यूएबल टाइम निकाल के हम लोगों को अपने ज्ञान के द्वारा हम लोगों को अपना ध्यान और समय दिया। साथ ही में मैं तुषार हेमानी साहब का भी धन्यवाद ज्ञापन करता हूं कि इन्होंने अपना बहुमूल्य समय हम लोगों को दिया। साथ ही मैं आप सबों का शुक्रिया अदा करता हूं। धन्यवाद।
थैंक यू सर। एक अनाउंसमेंट है, बाहर बुक फॉर लॉ एंड प्रोसीजर जीएसटी अपीलेट ट्रिब्यूनल की है, रिलीज बाय द हैंड्स ऑफ जजेस, जो कल हुआ था फॉर एआईएफटीपी मेंबर्स। उसको एक डिस्काउंटेड रेट 700 पे इशू किया जा रहा है, विच इज़ रिटन बाय एडवोकेट एंड सी अभय देसाई विथ अबाउट 200 साइटेशंस। तो बाहर किताब अवेलेबल है, आप लोग देख सकते हैं। सेकेंड, हमारा अब लंच के लिए हम लोग ब्रेक कर रहे हैं, विद इन हाफ एन आवर विल बी बैक, और इसके बाद एक लास्ट टेक्निकल सेशन है विच इज़ ऑन एआई एंड साइबर सिक्योरिटी। तो आप लोग से रिक्वेस्ट है, प्लीज़ लंच करके आधे घंटे में हमें वापस यहाँ असेंबल होना है। इट विल बी अ प्रैक्टिकल सेशन, ज़रूर अटेंड करिएगा, कुछ नया सीखने मिलेगा। थैंक यू। Good afternoon, everyone. We'll be starting the session in a couple of minutes, so request everyone to please settle down.
डिटेल दे देना. अंकित करेगा. Good afternoon, everyone. Shyam. ले, अंकल बोल देता. Good afternoon, everyone. After a heavy lunch, I welcome you all to the last and final technical session of this conference. I will request C.S. Shyam Agarwal to please escort our Honorable Speaker Sri Vijaya Srinivas Kotapalli to the dais. Shyam Agarwal is also the moderator, and Sir Vijaya Kotapalli has travelled all the way from Hyderabad for this seminar. I further request Prasanta Kumar Mishra to please come forward and share the dais for vote of thanks. I will now request Shyam Agarwal to start the session.
Before I start, I would like to introduce our speaker of the day, CA Vijay Srinivas Kotapalli, sir. He has over 23 years of professional experience, and his credentials include certifications as CISA, CFE, and Certified Cybersecurity and Insolvency Professional. He also holds an advanced diploma in cybersecurity and data protection from Nalsar University. He brings his expertise in forensic audits, fraud investigation, information system audit, and cybersecurity audits. He has conducted them for listed and unlisted companies, providing fraud and risk management consultancy to major banks like Citibank, HDFC, and Axis Bank. He currently serves as a director on the board of Association of Certified Fraud Examiners Hyderabad, and previously served as the ISACA Hyderabad chapter board. He is also the co-opted member of the Board of Studies Operations at ICI New Delhi. So we welcome sir to the City of Joy, Kolkata, with a big round of applause, sir. Thank you. So before we start the session, we like to felicitate sir. So I would like to call Mr. D.N. Mandal sir to please come and facilitate our speaker of the day, Vijay Srinivas Kotapalli, sir. A shawl and memento for Vijay sir. Thank you, sir. So before I start the session and hand over the proceedings to Vijay sir, would like to have a chit chat after a long lunch break. So थोड़ा एक बार कोई हाथ उठा सकता है? How many of us have ChatGPT installed in our mobile? ChatGPT कितने के पास में है? 1, 2, 3. बाकी लोग के पास ChatGPT भी नहीं है. I think just 5 or 6 people out of around 70-80 people in the room. So sir, the session today will consist of different tools जो आज ChatGPT हम लोग सुनते हैं या गामा सुनते हैं या Copilot सुनते हैं, Grok सुनते हैं, बहुत सारे ऐसे tools हैं which we can use in our professional life. जैसे सर क्या करेंगे? Sir will have a use case कि how well we can use those tools and हम अपने office में implement कर सकते हैं with respect to that tools and कैसे how better can we manage our profession, our team members to give more efficient and effective work with less amount of time. He will also touch upon cyber security and the new data protection bill. How many have heard as data protection bill जो नया आया है? As advocates or as chartered accountants, we are going to have a new vertical of practice with respect to this new DPDP Act. So there are many more acts and laws that are coming into picture by the government with the advent of technology. So without further ado, I would like to request our speaker of the day, CA Vijay Srinivas Kotapalli sir, to please take over the session and give you all the insights. Over to you, sir. Thank you.
Well, good afternoon all. Good afternoon.
Good afternoon, sir.
I know it's very tough time for any person post-lunch, no matter of the age, and more so for tax professionals with the kind of weightage we carry in experience and all that. So obviously we'll have this little nap kind of environment. So I'll try my best to keep you awake. So the question already Shyam has asked with regard to how many of you have ChatGPT or Gemini, Grok. There are many such tools. I mean, if you say what exactly is artificial intelligence or what kind of changes are happening across the globe, for your kind information, every week there are around 40,000 AI tools being released globally. Every week, 40,000. Okay. So what exactly is this AI? Before I get into use case, let me share a couple of insights. This is based out of, basically it has more core from the machine learning, wherein they have trained the machine on the data, on various human patterns, all these things, so that it become intelligent in a way it can understand the anomalies, patterns, wherein it can help respective human beings, whether it is a professional or a worker, doctor, scientist, chartered accountant, tax practitioner, advocate. So it has got the training, and over a period it is getting improved more and more as we start using in our practices or in personal life. But only problem here is when it comes to this artificial intelligence, it can't control Hello? Is it fine? Yeah. So only problem with the artificial intelligence is it can't control in a way that it gives a composed kind of response. Okay, so why? Because every time it generates a new content. Every time when you ask a question, it generates a new content based on the past learning and the patterns. So that's the reason if I'm asking a question about some citation, let's say we have heard about 158B, CC and all. If I'm asking about certain citations, it may not give a right answer because it is meant to create a new content, but while creating, it will try to refer to the sources more close to that income tax sections, and whatever it comes across, it tries to compile and give it to you. That's the problem now. You might say in that case, why I should be using it? As I said, this is still in the earlier stages and we are moving something called agentic AI, which is going to have the kind of human intelligence as part of it, wherein might be in few years, we might see a properly developed agentic AI which can respond to any kind of questions in whatever way you ask. Okay. So this particular limitation, and there is also questions, I am not sure how many of you heard, there is a debate happening across globally. I mean, October 1,50,000 jobs have been laid off in US and previous month around 80,000. So it's becoming more common criteria. So you might ask saying that whether AI will replace the professionals or practitioners. For me, my answer is professional is something not just out of the knowledge, it's out of the experience, it's out of the interpretational skills, it's about the kind of training what we get over a period while interacting live with the clients, with the regulators and all. So it can't be replaced merely by adding certain words. Okay, that's the intelligence what we carry as a human, is it not? So for me, I don't think AI will replace the professionals, but it might replace certain blue collar jobs, workforce, which doesn't require any kind of interpretational skills, or it is merely just giving certain kind of drafts or whatever it may be. So it might replace those jobs, but definitely not the professional. For me, AI will replace the professionals on that day when it replaces the human beings. Okay, my personal view, because to that extent we are safe. But as I mentioned, it is also equally challenging for us because AI is taking over part of our works, because we are not having the kind of resources what we used to have 10 years back. If I recruit a trainee, the kind of passion what he used to show in the work, or the kind of interest what he used to show, the kind of concentration what he used to show, maybe back in 10, 15 years, it was so good even if I go back more and more. But it started diminishing because kind of education system, the kind of pressures what they have, like everyone is settling by 21 years kind of thing. So they are unable to put that kind of focus in the work. So the problem here is the resource. We are not having a quality resource at our offices. And we are also having the work pressure in terms of regulatory compliances and clients walking in with different kind of tasks, not supported by the resources. So it's become very Herculean task for us to do that kind of quality work by ourselves, is it not? So in that scenarios, I can probably take the help of AI, where it can improve the quality of my resource person, or to an extent what he is unable to do, it will help me do that particular work. Let's say if I have to draft a response to one particular show cause notice, and if I give this job to him, if he is not so good in English or whatever it may be, again he will be Googling or trying to draft something, wherein once it comes to your desk, you might see that there are so many mistakes in English itself, forget about the actual law. Then you start correcting and all, it takes a lot of time. So there, if I give input saying that what he has to do with AI, and it will give that content in terms of English or whatever it may be, then I will do value addition from the domain perspective, then my job is easier rather than trying to do the correction of grammar and all, is it not? Okay, so that is where AI is going to be helpful for our professionals, wherein it will help the resource constraints, it will help me the knowledge constraints also. Let's say yesterday some notification has been released by GST, or some press release has been released by ministry. Unless it is being circulated through WhatsApp or news media, wherein most of the time it will not be in the same manner, it will keep changing its shape. By the time we receive, the interpretation might have actually changed. So I have to go through the notification, read, then only understand what exactly it is meant, is it not? So there I can probably take the help of AI to pull up that notification and try to provide me the key concepts, key areas of it, and also try and compare with why this particular section or press note has been released, why it is, what is the purpose of, is it about subsidizing some other earlier case studies? That kind of interpretational help I can take from the AI. Okay. So why I am speaking so much as an introduction kind of thing, because we can't avoid, it's inevitable. As much we can't avoid the computers 20 years back. Okay, probably you would have heard news that all the what you call professionals and all, they were on strike when the calculators were introduced 60 years back. in US. Okay, so now we have computers wherein earlier we were struggling, we are trying to see, say that threats about using computer. Similarly, this is the phase where AI is going to come into our lives and more quicker because every day one or other extra invention is happening in some or other field. Okay, that's where we should be cautious. So we should be like 5x in adoption compared to the computers. Okay, so for computer I might have taken 5 years to adopt, but AI I might have to spend 5 months at least to pick up that kind of pace. Okay. So agenda for the day, I've picked up these cases. It's all your patience. My flight is at 8 o'clock, so I can continue till the last moment. It's up to you. I mean, you are the people obviously should be the beneficiary. So if you show interest, I can continue up to the last 9 cases, but I'll try to cover as much as possible. Okay. So taking up the GST case study, what I'll do is I'll initially start with, because I believe many of people have not used or have ChatGPT kind of thing. Why ChatGPT? Why I'm referring to ChatGPT, though there are many such tools, for the reason that ChatGPT by OpenAI, a company which is having supported by Microsoft up to 49% of investment till 2 months back. Okay, so this has started its research in 2012, 2018 they have released a beta version, and 2023 they have released a global beta version where the accuracy percentage, let's say if I'm asking a case study, the kind of accurate answer what it was giving around 45-50% at the time. But over a period of 2 years, the accuracy has reached 90%. Okay, just say, let me ask a simple question before I get into case study. Let me ask, connecting with the earlier subject presentation what we had, provide me with some case scenarios under section 115B of, I'm not sure whether the section is correct because though I'm a chartered accountant, I've left this domain of taxation maybe 12 years back. So please correct me if the section is correct or not. The same section, I believe that's the section what he has referred earlier speaker of Income Tax Act 1961, because I'm trying to be precise so that it can connect with the local laws of India. I'm just giving a very vague prompt, nothing reference, no kind of open kind of thing. So what it has given, is it anywhere matching with that? I'm not sure, is the section is correct, 115B? Yeah? Are you thinking, is it anywhere relevant? Nowhere relevant, is it not? So, 115 BB, okay, is BB, yeah, oh fine, let me just, okay, maybe 148A, because you can probably relate with the, so because I have not given any context, I have not given any kind of boundaries, so obviously I am leaving the judgment to the AI to think on its own and give whatever response, is it not? So here it has given some conducting of inquiry under 148B, yeah? Yeah, see, exactly. So here whatever we get responses is not proper. And this is what happens if someone uses the AI without domain expertise. Okay, if I come back to my question, earlier question saying whether it will replace professionals, because client might put this prompt, but he may not get a right answer, because domain is something which we are strong in, where we know how we can control. As a practitioner, you might define a prompt in a proper way, where you say that, okay, you give certain case scenarios, you give examples, you give your experience saying that based on that you retrieve, then there is a 80% to 90% chances of getting a right answer. Are you getting? So that is where I again feel very confident that AI definitely will not replace, because domain first. What? Yeah, no, it is GPT-5 is updated very quickly. It's not about, it's about the, that's what. I'm intentionally showing the wrong answer for the reason that, we are all tax practitioners. So I'm saying don't directly jump into AI. You have your domain first, and then it's like, just to give an example, I have an intelligent article student. I've recruited some intelligent intern. Okay, he has completed certifications, who has done University of some Michigan, whatever it may be, brilliant. But can you directly give some work without any guidance? Is it not? We can't give. No matter how intelligent it is, I have to guide him. I have to give the parameters. I have to give the subject. Then he'll work smartly compared to the others. Similar is AI, wherein it can work if only your domain comes first. If you directly jump into that, then it's going to take you into the wrong route. For that sake, I'm intentionally given this particular example. Now let's say how I can get a right answer. That's where I'll present my first case study, wherein I picked up this GST notice issued under I think DR1, DRC 1A, some ITC fake related ITC related notification. So what I'll do is, I'm trying to share this notice. As you can see, I've ensured that the confidential data is not exposed. Okay, we'll also see a tool wherein I can mask this without my manual intervention. With running a code, how I can mask this particular entire content. Okay, so I'm sharing this with the GPT with a properly structured prompt. I'm not going to give saying that please prepare a response notice to that. That's a regular thing. As a domain, which I've taken the help from my partner, I've designed this particular prompt, and let's see how it works if I give a proper prompt. And just to mention, this is the prompt wherein I'm giving the context. I'm providing the section, that is the domain. As a domain, I know that which section it pertains to. What are the things I should be extracting from the notice? What are the relevant content I should be comparing before I start responding? How it has to be done? Everything I have designed. This entire thing is called a prompt. Okay, there is something called prompt engineering, wherein a common language will be structured in a way that it can extract a right answer from the AI. That is called the prompt engineering, basically. So I'll just copy this entire prompt, go to ChatGPT. Let me start a new chat. I'll paste this. What I'm using it for, I'm asking it to analyze this particular GST notice while giving what context and all, and let's see what kind of response it gives. When so as you can see, it is trying to analyze. Earlier, without any analysis, it has just spontaneously given certain response. It is trying to analyze, and there will be certain steps where it keeps analyzing using its own coding and all, which anyway we will not bother about. Now, it has extracted the relevant content in the format what I wanted, first thing, notice. And the second, reconciliation approach, because this is what I've requested for it. Before I respond to your showcase notice, I wanted it to provide me steps what I should be following. And then verification with regard to the eligibility, which this section was not mentioned in the notice, but it has picked up with regard to ITC. And how the defense strategy has to be applied. Okay, say availability of proof, procedural ground, confirm the date falls within the limitation period. We check as any advocates, usually they check first this particular thing, service, notice and all. It has now properly acted in as if a kind of professional, exactly. And proper officer, whether it has been under the jurisdiction of that particular officer, whether he is eligible to give that kind of notice. Natural justice, because third thing, constitutionally, if I start questioning, date, jurisdiction, constitutional validity, then finally get into the provisions. This is what usually advocates or any representatives will be doing, is it not? Now, it started acting in a way what I will be expecting as a professional kind of thing. Okay, and of course, it is giving what kind of documentation should be maintained and what kind of timelines I should be following. It also given a draft response. What it says, in reference to above, upon detailed reconciliation, it submitted that ITC claim pertains to invoices duly updated by registered suppliers. All suppliers have filed their so-and-so. The alleged difference arises due to timing differences and late filing, not excess ITC claim and supporting document. So now, this work, if I entrust to some junior, unless he is trained or experienced, I may not get of this kind. Now I can spend very less time. I can just need to identify the respective sections or whatever it has referred or the content. So my job has got minimized. Are you getting? Okay. And before I go there, you might say how to get this ChatGPT, and very good news for all us Indians is, usually all these AI have very limited tokens. Tokens is nothing but how much I can communicate in a given period of time. So free versions will have very limited tokens and all. But now ChatGPT has given this gift to Indians saying that for 1 year, it is free, where you can communicate up to 10,48,000 tokens in any given point of time. Okay, so how to do that? I'm just showing, I will not directly demonstrate. Let's say you can click on this ChatGPT, connect with your Google account, and whenever I say Google account, don't try to connect with your personal accounts or the office accounts. You might create a new Gmail ID, pretty much easy for us to create a new Gmail ID. Create a new Gmail ID, connect with that particular thing so that your data is not getting exposed, and to an extent what is required, you start communicating only to that extent so that you are safe in certain way. Okay, so let's say I'll just try to connect with some Gmail account. So this is how you should be doing. Visit chatgpt.com, connect through Google, create one new Gmail ID. Once it gives, it will definitely ask your card details, credit card details, but nothing will be debited for at least next 1 year. Okay, later on you can anyway stop instructions. There will not be any instruction created also. It's only to validate that you are an Indian. The financial transaction is happening from the Indian perspective, and also accordingly for validation purposes. You'll get a message also saying zero amount has been debited. So once you are logged in there, you can click on upgrade for free, and as you can see, this is usually it was around $20, then they have discounted to 399 rupees, and then now from 4th November onwards, for 1 year, it is going to be free. So once I click, I just need to give my details and all, it will be valid for 1 year. So advantages of having a licensed version is the more number of tokens, more what you call high-end models which you can use, and also ChatGPT is also coming up with kind of agent mode. Just to give an idea, ChatGPT is also announced that they are getting into payment bank industry, wherein they will be taking license from RBI. So that means if I have to procure groceries in my house, I just give the list of groceries. It will do the search on my behalf through all Big Basket, all those Blinkit and all. It will search, identify the lowest price, and it will try to do the financial transactions through the payment bank and purchases your items for the best price possible. Okay, as an agent it is. So that is where it is moving towards. Okay. So for that sake, I always suggest that you at least have one, because it's free anyway for 1 year. Let's try, and you can try in a different ways. Okay, I'm going to demonstrate a couple of cases wherein you can take a lead from that and start practicing. And by the way, whatever content I'm sharing here, I'll be displaying a QR code. Okay, you can take a picture of that, scan it. You'll be having, you can download through Google Drive all those cases what I'm going to present now. Okay. So one we have seen CGST. Similarly, I can use maybe SGST also just to complete this particular. As you can see, I can copy maybe 10, 15 kind of images. Earlier it was 10 limit, but now it has increased. So I can just go to ChatGPT, again click on the new chat. Okay, this is a different account. Let me just log out and go back to my earlier account. Because if I have to activate it before you, I have to enter my credit card details, which I believe it's a bit of risky. This is not the one second. Because couple of accounts I would have already used in the morning for different purposes and also I'm just looking for some, okay. So here I can just continue with the same GST notice, and as I said, this is the prompt. I'll just copy the prompt, go back to this thing wherein I'm requesting for a response to SGST notice on different grounds, not exactly the same grounds what we have used in CGST. Okay. So it's going to take a couple of seconds to analyze and all that. Okay. So by the time it analyzes, okay, it started analyzing. It's a section which was referred in the notice. Of course, this particular notice was issued in one of the sessions which I have taken in Bagalkot. So one of the member has shared, which of course I have masked the information and all. So it has picked up with regard to those. It has picked up each of the segment, legal fee, agent commission, director sitting, and started doing analysis under the respective sections of the State Act, KGST Act. Okay, very specific to that, of course. And notification also it is referring, and what exactly is the legal test. Whether pygmy agent fall under any specific RCM entry under so-and-so notification, that's the question what it is checking. And what are the legal relevant points, and accordingly it concludes that pygmy agent are not included in RCM category. Maybe someone who is into GST domain, they can probably identify whether it is right or wrong. And director sitting fee, again it says qualifies as service supplied by director so and so, so and so. So it is giving all the interpretational aspects. So for me, once the notice is received, I just entrust this job to AI, let it give a output, then I'll call my assistant saying that, no, review this, and based on your knowledge or based on the books of material what we have, identify if anything is correct, then it comes back to my desk. So I'm saving a lot of time than taking the help of, because human resources we have experienced in our office also. If I don't sanction a leave for his brother-in-law's marriage, his work attitude will be different. Okay. If I give a bonus, his work attitude will be different. So human are somewhere biased by their emotions and all that, which can't, but here I don't have to worry about all that. Anytime, every time it will do the same kind of quality. That is where the advantage what we have. Okay. So let's, this is what ultimately the first case study. Coming to the second case study, this is one of the most important what I consider, because once we file a return, okay, nowadays it's become so frequent that very shortly we'll receive a show cause notice, or sometimes based on the scrutiny norms, we'll get the scrutiny being picked up. And most risky thing is, most of our clients, they walk into our office during the last moments of the filing dates, due date. Now that it has been postponed to December 10th, I think, I'm sure they would have relaxed. They might be start coming in from December 1st or kind of thing. So when you do this last minute filings, there is always a chance of missing out something. There is always a chance of committing some kind of mathematical mistake in your return. Okay, you can't go for maker checker where you do and another person will check whether it is right or wrong. You just upload. Okay, you see that, okay, written is upload, acknowledgement generated. If required, we'll see in the revised or whatever it may. So in that scenarios, there is every possibility of some show cause notice being picked up. Now we have many publications available in the market which shows what is the reason behind show cause notice. Even otherwise your experience might have already have your own repository saying why a show cause notice will be issued. Or if you are an association like yours is sitting together, you can discuss on what are the scrutiny norms usually nowadays you are getting. So all these, if you put together and give it to your GPT saying that these are the various show cause notices, these are the scrutiny norms, based on that, verify my ITR and identify if any issues are there. You might say, how I can share my ITR? Pretty simple. You generate your JSON file, you go to the, open the file in Notepad, remove the name or remove the PAN number. You can just find replace. Okay, and then you can share the dummy file, because rest of all financials is what matters, is not rest, other things we can change. That part can be done by even a 10th passed student also. You just say, okay, wherever PAN is there, wherever name is there, find replace. But I thought I'll not trouble. Nowadays, Infosys supporting income tax department and of course GST, it has its own wing, supporting in a way that they'll scrap through the social media handles. Let's say for example, client is mentioning an email ID in his return. Okay, obviously we know that email is linked to your mobile, mobile is linked to Aadhaar. So it's pretty easy through certain tools where I can identify what is the address from which this particular Gmail is linked to through mobile, your Aadhaar. Okay. So now these mails also will be having handles through social media. You have LinkedIn, you have Twitter, you have Facebook. And let's say client's son has uploaded a picture of a beautiful car saying my new car. Okay, these 3 days of trip to Switzerland. Okay, wherein obviously he's an independent, he's still dependent. Is it not? Your client's son is still dependent and he's taking this picture. And this particular machine, which is being supported by Infosys, which has around 270 AIs capabilities, it will run through that social media scraps, picks up all those stories posts, converts that into a cost factor saying that if I travel to Switzerland, how much cost it would have been incurred. And this put together from a given address versus the income declared from a given address, a simple reconciliation will throw the undeclared expenses. I was going to ask in that scenario whether it can be considered as the other information what he was referring to. Another thing is you might say that how they can access my social media without my consent, because Article 21 and all. And just for your kind of information, the DPDPA, that is Digital Personal Data Protection Act, exclusively exempts the government and its instruments. So they have every, unless someone constitutionally challenged, there is no barring for validating, getting through social media for legal purposes. Is it not? So this simple analysis is once you file a return, machine has already analyzed all your expenses. Once you file a return, now you have declared income, so immediately it will reconcile and everything happens in few minutes. It doesn't even take like days kind of thing, because we are speaking about what you call GPUs, which can process so quick, 1000 processings can be done within a millisecond kind of thing. Okay, so this is the challenge. Now before I file a return itself, if I have a what you call chance to identify what are all the risk what I am taking, at least I'll try to mitigate or at least take a consent saying, sir, once I upload this return, आपको ये chances होगा कि शायद आपको शोकॉज नोटिस आ जाए इसमें, ताकि क्यों बोले तो अब आप तो लास्ट मोमेंट में आ गए और ये इन्फॉर्मेशन जो मैंने पूछा था आपने नहीं दिए, तो ये चांसेस हो सकता है. So that kind of advice I can give with the help of the AI. So that's the case study what I'm going to demonstrate. So here I've taken a sample ITR, I've taken the 26 AS, also these are all demo files, and ITR 3 PDF, the same JSON once it is converted into PDF how it will be, and certain norms which could be like, say, if there is a difference between the tax audit report and ITR, these are the reasons. It could be picked up for show cause notice, or these are the various reasons why a scrutiny might be picked up. So with my limited knowledge, I am sharing this. You being a practitioner, you might have your own very good repository. Now I'll share all these, okay, and I've also included the FAQs issued by the department itself, why it might consider defective. I'm training my GPT also on this, and I also picked up a couple of articles written by various, this is also by department, I think there was this article written for BCAS, and also I've tried to take as much as information possible to train my GPT saying that once I upload this ITR, what are the chances of it getting picked up for scrutiny? What are the probability of a show cause notice might be issued based on these norms or these rules? Okay, so the prompt is, I'm saying I've uploaded the following documents. Please summarize so and so. Based on that, you update your understanding. And while I say so, at the end, if you can see, no need to provide me with the summary, because once you upload it, start reading out what was there in the documents, which we don't need. We know what is there in the document. Is it not? Our purpose is something different. So I'm saying, don't summarize. Once you have understood, just say yes, understood. Nothing much. Okay. So I'm going to copy this entire prompt. Okay, and I'm going to again GPT, let me just, and here for those, I believe it's a combination of various practitioners, advocates, chartered accountant, but those who are chartered accountants, you have your ICA GPT exclusively meant for direct taxes, indirect taxes. So in that case, you can directly go to that particular GPT, which will be much more effective than the regular GPT. Okay, but here I'm using the regular GPT, wherein I'm putting the prompt and I'm sharing all the files which I am asking it to analyze. Okay, and this is where your free version, the latest version, will help you. If you are going for the earlier version, these many files it will not support. Okay, it will say sorry, token is expired, you might come back tomorrow. But if you are going for the latest 1 year free wala, then you have chances of uploading multiple such files. Okay, so as you can see, this button is visible to submit. I'll just say submit. So it is reading the documents. You might say how quickly, I'm not sure how many of you seen this Rajnikant robo movie. Yeah, he'll just waves the book, he reads it. Okay, this is something like that. GPU is of that capability. You upload 5,000 pages, within few seconds it will read. It's a robo, basically Rajnikant kind of thing. Okay, it's still, as I said, irrespective of what I say, it might summarizing and all, but anyway, it's a free version for me, I don't bother. But usually, if you go for paid version, yeah, now it says yes, proceed. Now what I'll say is, my requirement is something, I'm saying that based on the ITR what I shared, based on the update what you receive, identify the possibility of the same getting a show cause notice. If so, on what grounds it might receive. Because I haven't reviewed that point into my ITR. Because as I said, last moment filing, obviously, I'm trying to put all into other expenses or other income so that I can push my return. So I'm giving these parameters and asking it to analyze from that particular thing. So once it says yes, proceed, I'll put this prompt. Let's see what kind of insights it gives. So it says, these are the possible based on the information what I submitted. Of course, general will not, it says audit not applicable despite turnover being 79. Okay, it's just giving, these are all red flags. These are not that you are 100% going to get show cause. What we are asking you to identify the red flags so that I can prepare myself or it can prepare my client. And more importantly, it is also giving what are the documents you should keep in hand. So what I can say is, I'll share this with my client before I upload. Those who are coming in the last moment, I'll run this. I'll share, sir, आपने अगर आप upload किया, ये risk है. आपके पास कम से कम ये document तो ready रखिए, जितना जल्दी हो सके. Once I upload, once you get a show cause notice, nowadays I think GST, there's a window of only 15 days wherein you have to respond. So in that scenarios, if you don't prepare your client, you can't get the documentation ready within short period. So at least this way, I am identifying what are the risks it has, what are the chances of it getting picked up for show cause or a scrutiny, and like say you can see high current assets, loan from others. These are the possible reasons which might be picked up for scrutiny or whatever. And nowadays I think you have seen that refund process next day itself. How many of you have experienced that? ITR 3? Almost all, is it not? So why confidently? Because they are now using machines like crazy. I mean, they have, India itself has what you call 25,000 GPUs has been dedicated freely for research. So if it can be done freely, you can imagine how much. Obviously 4,000 crores ऐसे ही ज़्यादा spend नहीं किए. I mean, they have spent a lot of that amount into this AI. That is where department is more confident, and that's where we should be cautious about. Okay. So it has given all that kind of thing, and what are the high GP ratio, current ratio, possibility of show cause. These are the various things, and what are the recommendations. Anyway, we don't need to bother. It's our own domain, which we'll take care. But I'm taking this help at least to safeguard myself, because ultimately कुछ show cause notice आ गया, the client यही बोलेंगे कि आपने क्या देखा, ये नहीं बोलेगा कि last moment में आया हूँ, यही पूछेगा कि सर आपने क्या किया, ये तो आपकी वजह से आ गया मेरा show cause notice. So at least you can probably identify what are the issues, is it not? So likewise you can try it on and next time आपने एक बार ये कर दिया, सिर्फ एक बार, बाकी का जो ITRs आपके साथ maybe 200, 300 returns still are to be filed. Next, your assistant has nothing to do. You just need to submit and say, please analyze. Let's say, for example, I have one more this ITR. I don't have to give the prompt and all. I'll say, analyze this also. Because I already trained, learned what has to be done. So no matter how many returns I'll upload, I'll just run this prompt every time, take that printout, discuss with the client, and accordingly involve himself also. Like now you can see it has started performing all those balance sheet wise analysis, because now it learned exactly what you are expecting. So more and more you start giving ITRs, more and more smarter, and that's where you are getting this 1 year free for a reason that Sam Altman is a perfect businessman. Instead of spending on advertising, because training के लिए, I mean, whatever they have trained up to 2018, they have shelled down around $600 million. Now, उसको कुछ ज़रूरत ही नहीं, क्यों? Because they have left it out free. You started uploading your own cases, you started training it. Obviously, it is getting trained. So at the cost of our knowledge, our this thing, they are getting trained freely. But our advantage is because of the resource constraints what I have, somehow I'm trying to make best out of my practice with the help of these tools. Is it not? So it started analyzing, and all these within few seconds. You can imagine the kind of value addition what it gives. It has also considered the custom duty part which has been declared. Yes, sir.
Suppose I give an instruction that this file is confidential, or you don't have to use this for training. Still can they?
See, ultimately when it comes to, I mean, Gmail we trust a lot. In our mobiles we have Gmails. But what is that? Do you have an NDA with Gmail? Have they ever signed a non-disclosure agreement? We don't have any such. Okay. We believe that it is secured for the reason that no, it's for some reason. I mean, of course, we believe Microsoft, we believe Gmail than a friend who has created the similar applications residing my neighbor for the past 30 years. Okay, that's how it is. So here, no matter how much of assurance they give, how much of confidence, we have to be, as a professional, that's what we should be concerned about. How much ever is required, that only we'll give. We'll see that names are not shared, email, mobile numbers, financial figures किसी का भी हो सकता है. So if I keep that, as much you can share, you can share. As you are saying, more and more you share, more and more it will be expected. You can ensure that you don't share the personal identifiers or the confidential data. No matter what, because that is meant for training. Model itself is developing based on training. It will say that sorry, I'll definitely oblige you. आप भगवान है, आप जो बोलेंगे वही मानूंगा. But ultimately, because model बन रहा ही training के ऊपर, नहीं तो model ही नहीं बन पाएगा. Unless you train it, it will not mature itself. That itself is a model. So you have to be cautious in that grounds. GPT, yeah. Actually, it is meant for transformation, but anyway. But you can resemble that. See, temporary chart and all, it doesn't retain in your credentials, but there is no assurance that it will not transfer the data. Okay, it has been tested through a couple of cybersecurity professionals. They have shown this, especially DeepSeek करके है एक China का. Okay, though it doesn't display, once you log into that, it started accessing all the engines in your Gmail, Google, Chrome में जो है, Mozilla में जो है, it started accessing all that information. So you have to be cautious, but to an extent, if you are careful, I think good enough for us to go ahead. Okay. So this is about the second case. Third case, I think good number of people are into representation as well. Income tax representation या GST representation में क्या होता है? You would have filed the return somewhere back in 2021. A notice would have been received based on the time frames, whatever it may be. You would have received certain notice, and immediately you would have requested for adjournment, and there is another communication. There is a series of communication happening. And one fine day, once the March 26 time barring comes, there will be a pressure of compiling this information. Now, unless someone is very structured of maintaining folder-wise, year-wise, name-wise, filing, utna, I don't think even if we are, our assistant are not so, जैसे अभी सेव कर देंगे बाद में रीनेम करेंगे वो कभी नहीं होगा. तो जब वो टाइम आता है जब यू स्टार्ट सर्चिंग अरे क्या दिया था, सेकंड रेस्पॉन्स क्या दिया था, थर्ड रेस्पॉन्स क्या दिया था, फोर्थ रेस्पॉन्स किसने दिया, कौन सा पार्टनर ने दिया, मैं नहीं था, कोई दूसरा पार्टनर गया, कौन गया. So lot of questions will be coming where it will be very difficult for us to keep a track unless you are very organized like Big 10, Big 20 and all. So in that scenarios, you can take the help of one particular AI tool, which is, I'll just show you how directly you can go. You can go to your Gmail accounts. You can log into your Gmail accounts. There is a direct access way also. You just click on these 9 dots. And at the end, you have something called Notebook LM. Okay, Notebook LM. This is out of a concept called RAG, Retrieval Augmented Generation. That means, though it is AI, it will not work like a large language model where it will pick the data from its own training. It will pick the data from the content what you give. It will not go beyond the boundaries. आपने अगर GST Act upload किया है, वो GST Act आपने आपका जो clients को दिया है opinions, जैसे कि आपने 15 clients का opinion जो भी है वो bundle करके उसको दिया है, it will be depending on only those 15 opinions. It will not go beyond that. It will not use its brain. Okay, that's where the concept of. So here, I'll just show you the kind of files. Here क्या करेंगे आप पहले आप Notebook LM में जाते ही you will find this kind of screens. So first step is to create a note. Now beauty of this is I can create multiple such notes. अगर मेरे पास 1000 clients है, I can create 1000 notes so that I don't have to struggle on one folder. In that I keep uploading wherein it is not only tracking, it is also analyzing and helping you out whenever you require. जो भी information चाहिए. Okay. So I'll click on this create new. अगर इसमें free version है, at a time you can add up to 50 files. 50 files तक upload कर सकते हो free version में. Paid version में you can upload up to 300 files in every single note. So अगर 1000 clients है, 1000 clients you can upload 300 because yeah, pro version, if you have a pro version, because pro version comes with 5 terabytes and all that. Okay. तो अगर इसमें क्या करेंगे पहले, I've just given this, let's say, to start with, I'll just put it in reverse order. You initially received a show cause notice, okay, from some, based on certain thing, with regard to income escaped assessment, and then you have given a response to show cause notice. These are all synthetic data, by the way, response to show cause notice. and then there is an order issued, and then there is a memorandum of, I mean, of course, these are all not in a proper order, but you can imagine, like there is a demand notice, there is a adjournment request, then it has gone to tribunal, then to high court, so and so, so and so. There are like around 15 communications have happened over a period of various years and months. So how can I take the help of Notebook LM? I'll just dump all these into this particular Notebook LM. अगर आप ये पूछेंगे सर अगेन कॉन्फिडेंशियलिटी का बात आ रहा है तो जितना आप Gmail को ये अभी Gmail में ही इसमें से ही गया था ना मैंने. I've gone through Gmail only. So if you are able to communicate with client all the confidential information saying that ये information आपने नहीं दिया, ये information दो, okay. So obviously it's in the same in architecture. I don't think unless you take care of the names and all that anyway you have to be very careful not to share the names and all. As much as caution you exercise. So कितना टाइम लिया उसको पूरा पढ़ने में? Hardly few seconds. Okay, पूरा information. जैसे कि I want to see the kind of timelines based on which it was, what are all the documents it has. Okay. पहले एक माइंड मैप देखेंगे. माइंड मैप में क्या होगा, आप क्या क्या इश्यूज है, ये 15 डॉक्यूमेंट्स में क्या जो है, व्हाट आर ऑल द मेन इश्यूज, व्हाट आर ऑल द फैक्ट्स ऑफ द केस, ओके, व्हाट आर ऑल द वेरियस नोटिसेस यू हैव रिसीव्ड, हु हैज रिप्रेजेंटेड, वो पूरा जो है आपको माइंड मैप में आ जाएगा. जैसे कि आप, मैं एक बार क्लिक किया, सो आउट ऑफ दोज 15 डॉक्यूमेंट्स, इनिशिएशन एंड रेस्पॉन्स, शोकाज नोटिस, इसको अगर क्लिक करूंगा कौन सी ग्राउंड्स पे शोकाज नोटिस आया, what was the SSS's preliminary key kind of concepts, what was there in the adjournment request, how much time we have asked, what was that adjournment order has speaked about, and what was the ultimately comprehensive. So everything at a click of a button you will get to see what was there in the document. Okay, first thing. Second, I'll go to this reports. I'll go to these reports. And let's say I want to identify what exactly is this case summary. जैसे कि कोई आर्टिकल स्टूडेंट ट्रेनी का टाइम हो गया, वो प्रॉब्ली ही हैज मूव्ड ऑन टू डिफरेंट जॉब, तो उसको नया वालों को अगेन हैव टू ब्रीफ आउट एवरीथिंग, ही हैज टू गो थ्रू ऑल द डॉक्यूमेंट. इंस्टेड ऑफ दैट आई कैन जनरेट ए brief document out of all that case study. It will take a couple of seconds to a minute kind of time, and it will give a complete summary of the particular document, like when was it issued, what was the reason behind the particular show cause notice, what was it submitted, okay, and who has represented, all that stuff. Okay, it will take a couple of seconds. By the time it generates, we will move on to the another case within the same platform. मैंने ये कहा था कि आपको अपडेट रहना चाहिए, जैसे कि नोटिफिकेशन होता है, प्रेस रिलीज होता है, सर्कुलर्स होते हैं, कभी मीडिया में दे विल पब्लिश समथिंग इन मीडिया. सो एवरीथिंग एज अ प्रोफेशनल आई हैव टू बी अपडेट, बिकॉज क्लाइंट कभी कभी रात में कॉल करता है, सर ये आपने सुना है, शाम में ये नोटिफिकेशन आया. ऐसा ना हो कि आप नहीं ये नहीं बोल सकते कि मैंने नहीं सुना, ये एम्बरेसिंग बात हो जाएगी और क्लाइंट का ट्रस्ट भी आपसे उड़ जाएगा. इसीलिए यू हैव टू बी वेरी अपडेटेड इन टर्म्स ऑफ व्हाट्स हैपनिंग. सो व्हाट यू कैन डू इज, I'm just sharing the kind of what you call the advice what I've given to my partners. Okay, so there is this platform called Perplexity. एक notepad में वो भी type करता हूँ. आपने LinkedIn सुना है? LinkedIn platform. This is backed by LinkedIn. Perplexity is backed by LinkedIn. Okay, so what I'll do is, I'll go to this Perplexity, okay, and I'll put a simple prompt, of course, just to show. So ये वाला prompt है. मैंने क्या बोला? Please find the 10 online resources which provide the latest case studies and judgments under income tax law, ranging from IT to Supreme Court. This site is not product, क्योंकि advertisement का भी pages होते हैं. I don't want that pages, but get me the URLs only. I don't want anything. Okay, so what I'll do, I'll just put this prompt in Perplexity. Perplexity, क्यों Perplexity? Because Perplexity is backed by very good research. Okay, it connects with live sources. It also gives you from which sources it has picked up, so that it will be transparent. You can also judge whether it is right or wrong. Okay. So मैंने वो prompt इसमें डाल दिया. So as you can see, it is picking up from various resources and all. And I have asked for public sources, because Tax Guru, Tax Sutra, I have to subscribe. I don't want those sources. I want.
Suppose I have a paid subscription, say Tax Guru.
Yeah, even then it can't access. Even then it can't access. Unless, yeah,
it cannot access.
It can access provided you give complete control. There is something called Comet. Perplexity का own website है वो.
Browser है.
Yeah, browser. Sorry. Perplexity का own browser है called Comet. Just like Google Chrome, Internet Explorer or whatever it may be, Perplexity का खुद का ये है. अगर मैंने इधर AI assistant activate किया, तो आप जो बोलेंगे वो करेंगे. जैसे कि आपने बैंक लॉगिन किया है यही वेबसाइट में, आप ये बोलेंगे कि ये वाला इंफॉर्मेशन नेम, IFSC कोड, अकाउंट नंबर, you ask it to create an account, initiate a transfer, wait for my OTP updation, it will do that. Everything, this is more like an agent, AI agent.
So what I understand through this browser, Comet browser, and for Perplexity,
yeah,
if I give my subscription details, say Tax Guru,
you have to log in through same browser,
browser,
enable it to access your enable it to access your resources. You have logged in through Comet only.
Yeah, but
Tax
there is
Sutra.
some configuration which I have to do, or
Nothing.
just
You go to Tax Sutra, only thing is that you use Comet website,
Yeah.
what your browser, you log into Tax Sutra within that, and then you say, okay, I've already logged into that, now your job is to pull up the information. It will do for you.
It will do.
But again, it's all trust. Whether I can trust this thing, there is always a risk associated with it. Obviously, just like mobile banking, though it is very facilitative or convenient, there is always a risk, is it not?
But
So
that's
that,
a browser of Perplexity.
yeah, it's a
but
Perplexity browser
in
only.
this browser, suppose I go to ChatGPT or Gemini.
No, it will not do. It can't do. It will
Only
directly.
Perplexity.
Yeah, because it is acting as an agent on behalf of you. Whatever you are doing in the browser, it is doing on behalf of you, based on based on the control. Because once you give that control, it will take the control, starts executing in that.
Thank you.
But I would suggest that okay, Tax Sutra and all, there is nothing like financial transactions involved in it. You can pretty much use, but not to use in other domains like banking or income tax, any website, which is always risky because it might copy the credentials from that.
Thank you.
Okay, you're welcome. So here, what I'll do is, I'll just copy जो भी URL उसने दिया है, वो कॉपी करके मैं अपना वापस नोटबुक LM जाऊँगा, वहाँ पे create new क्लिक करूँगा, and you have earlier we have uploaded 15 documents. Now instead of uploading documents, I'll give the web links only. So I'll click on this website, paste all the links. So what I'm saying, I'm creating a notebook based on the links where it keeps extracting from that information, and every day I can put a prompt, कल क्या हुआ, क्या क्या अपडेट्स आया, वो दे देगा आपको. आपको चाहिए ऑफिस में सर्कुलेट करना है, क्लाइंट को आपको न्यूज़लेटर के जैसा बनाना के भेजना है, आपको खुद पढ़ना है, जो भी ये कर सकते हैं. एंड इट इज़ सो हेल्पफुल. जैसे कि इतने सारे यूट्यूब वीडियोस है, वेरियस सेक्शंस, जैसे कि इंस्टीट्यूट में कुछ 3 आवर्स का सेमिनार हुआ है, कुछ सब्जेक्ट ने एक्सपर्ट हैज़ शेयर्ड इन्फॉर्मेशन, इट बिकम वेरी डिफिकल्ट फॉर यू टू गो थ्रू दैट वीडियो. You share the YouTube link to this particular notebook, ask whatever you want. It will give the brief of the entire video transcript in a perfectly structured way. So it has that kind of uses what you have. So, no, Perplexity, why I have demonstrated is because it has the capability to do research and also get through the sources and display the sources. Otherwise, the same prompt can be given in ChatGPT also, saying, provide me those top 10 links and all, it will give. But I'll not sure from where it has picked up how. Here at least I can, yeah.
Source.
Here I can see the source, and I trust Perplexity because it is built on, it's a asset for it. Research itself is asset for Perplexity. It is based out of it. In fact, just to share last Saturday, there was a session taken for CID officials and all, and ED and all. So they were saying that the majority of them, they are using Perplexity. You can imagine that.
Yes.
Those kind of regulators, they started using it. So there is some quality in that particular thing. So here, once I have done, I can probably आपको ये 15 जो भी links लिया है, उसमें से आपको कुछ training video generate करना है. जैसे कि स्टाफ को ट्रेनिंग करने के लिए। अब सिर्फ यू क्लिक ऑन दिस वीडियो ओवरव्यू, एंड वाइल क्लिकिंग यू कैन ऑल्सो से विच लैंग्वेज आपको बांग्ला में चाहिए, आप बांग्ला, यू कैन सेलेक्ट बांग्ला लैंग्वेज, आपको बांग्ला ऑडियो चाहिए, बांग्ला में सेलेक्ट कीजिए, क्या एक्सप्लेन करना है, कैसे एक्सप्लेन करना है वो भी आप इधर टाइप कर दीजिए। It will create a video, a 30 minutes to 1 hour kind of video, where it will, based on the last updates, it will create a training video for your staff or client or whatever it may be. Of course, अभी generate करने में थोड़ा time लगेगा, इसलिए I am not risking of generating, but mistakenly I have already clicked, so it is trying to generate in English video. But mind map, again here also you have what kind of notices have been issued, what are the areas it has addressed, everything it will cover. Okay, एक बार आप ट्राई करते दीजिए। I mean, you don't need to worry anything about this technology, whatever it may be. I mean, this might be new. As much you practice in income tax, GST, ऐसा नहीं है कि आप जो भी सेक्शन आपसे पूछो आप फट से जवाब देंगे। आप तो कम से कम रिफर तो करना पड़ेगा। Maybe even if it is 139.9, if I ask specific question on that, you may not be in a position to answer, because as we need at that point of time, similar is technology. थोड़ा time spend करेंगे, I think we are the people who can immediately equip it compared to the other people, because being in that kind of perception what we develop, we can easily understand this. So my request is just give a try, see how it is working out, and slowly you start adopting in a different way. Any public source, in fact we have given this to one of the bankers. They wanted to extract the penalties imposed by RBI. Usually they put in public press release, where they, nowadays it become very common to penalize banks for various reasons, KYC, non-compliance, cyber security. So they have requested to give this kind of thing. So where we have given direct link to the particular thing, it extracts every time there is a press notice, it identifies on what basis penalty was levied, what are those gaps which I identified, so that they can try to fill that particular gaps before the RBI inspection comes next. Yes. Everything. It's only that, see, initially it will go through that, everything, but it will not capture. It will capture only when you start prompting it. Yes. Pretty much. It will give. Any time. See, what it does is, first of all, it will analyze whatever is there, okay, on a random basis. Let's say you have 20 pages, 20 tabs in CBIC website. So it will randomly identify what are all the content is, what are the headlines, and randomly open certain documents also, and keeps it updated, saying that if you ask any questions, how it has to reach out to the respective pages and extract that. That's the part it will be ready with, not that the data will be extracted. Once you put a prompt, it knows where to go. We call it as proximity tokens. So it knows where to go, how to go, and immediately start retrieving. That's the advantage. So compared to, you might say that Google search तो वही कर रहा है, Google search कुछ नहीं कर रहा है, वो search करके क्या है links दे आपको दे रहा है, आपको खुद पढ़ना पड़ेगा, open करके. ये जो है पढ़ के prepare ready है, ताकि आप जो भी question पूछे आपको जवाब दे सके, फट से. Okay, so I think it has already created a mind map. So क्या क्या assessment, reassessment के ऊपर कुछ notices आया है on these. I think recent publications, I am not sure how many of these. So you can see that just with some kind of links, I got information what I am looking for it at my desktop. Okay. So this is, and you can try in different ways. जैसे कि आपको sample, जैसे कि CGST का notification circulars जो भी आते हैं, सर ने एक पूछा question, I'll just copy this link, go to notebook LM, create notebook, और website link वहाँ पे पेस्ट कर दूंगा, insert करूँगा. Few seconds it will take to analyze what exactly it is, and I can ask what are the notifications issued on classification. Okay, when was the last notification issued on type of supply, whatever it may be. So you can start interacting with that particular. Let's say what was the recent notification issued on classification. So because established what has to be done, how to reach out, it starts pulling the information, and so it says February 24, this is the notification 247/04/2025, clarification regarding GST rates and classification based on the recommendations of GST Council in 55th meeting. at Jaisalmer. So as per the website update, it has given. Yeah. So what we'll do is at the end we'll take up the question and answer because other things we'll do that. We'll do that. I'm available pretty much as long as you are there. Okay. So let's move on to the next case study. So here, Notebook LM is an RAG. If in case you want to have LLM kind of capability, at the same time you don't want to share it outside, then आपने Adobe सुना है? Adobe Acrobat and all? Adobe? I think we are pretty common we use. So let's say I'll open this file in Adobe. आजकल Adobe भी थोड़ा payment का start किया है, लेकिन usually it will give 1 week 10 days license if in case you want to try. I can ask AI assistant without uploading my file. और यहाँ पे beauty क्या है? आपके पास एक 60 पेज का agreement है, some agreement, okay, tri-party agreement, and you are trying to understand assuming that 60 page is scanned and converted into PDF. आपको मालूम है कितना मुश्किल होगा, आप Control F काम नहीं करेगा क्योंकि वो तो image है जो PDF ने convert किया. In those scenarios also, you can open in Adobe, you can put the question, it will convert, extract as OCR, okay, and identifies the information what you are asking, it starts responding. So Control F काम नहीं करेगा भी, AI will start working on it. Okay, I'll put a question. Let's say this is all some Indian law reports. Let me see what is the context because I'm not sure what this document has. Let me ask some questions. Let me ask questions relevant cases under regarding reassessment. इसको थोड़ा drag करता हूँ. I'm not sure whether I'm able to zoom it. Okay, ये वाला zoom होगा लेकिन ये नहीं. So relevant regarding reassessment and present in tabular format. जो भी है reassessment you pull out those, and I also want in a tabular format. वो request डाला हूँ wherein I'm not uploading this document elsewhere. I'm giving this example wherein you can implement in any kind. Just to give an idea, you have a 60-page bank statement provided by your staff, your client, wherein you want to identify a related party payments. You know the name, in the AI assistant, you put say how much payment has been made to so and so Shyam Agarwal. Okay. So immediately it will identify, it will go through 60 pages, identifies the name, identifies the amount, gives you a total of those transactions and also the individual transactions. कितना आसान है, otherwise you have to convert into Excel, कभी convert होगा, कभी नहीं, कभी convert होगा तो भी एक ये sheet में रहेगा, दूसरा sheet में चला जाएगा, कितना मुश्किल will be facing. So now you can see, because I was in a tabular format, it started giving all that information from this particular PDF itself. आप ट्राई कीजिए कभी एडोब ओपन करके, आप इनकम टैक्स एक्ट नया वाला जो ओपन करके उसमें से आप जो भी क्वेश्चन पूछना है ये असिस्टेंट से पूछ के देखिए how much it is responding. You are not using any other tool also, the same tool what you have been using, is it not? Okay, so this is about this particular third case. Let's move on to fourth case. थोड़ा last में लगाऊंगा क्योंकि थोड़ा time taking है. It's like creating your own agent who can respond to any kind of queries, whatever queries you ask, that we'll keep it at the end. And compliance, मैं बोल रहा था कि we can take help of AI in different forms. जैसे कि अलग अलग से ड्यू डेट्स है, जीएसटी का फाइल करने का, इनकम टैक्स का अलग अलग से ड्यू डेट्स है, एंड एवरी टाइम यू फॉरगेट और योर क्लाइंट फॉरगेट्स to make that payment or file it. So either you have certain tools or which will give you alert, or you update in your Google Calendar which will create an alert. So what we can do is we can make a simple adjustments which we will get the best of the output. What I'll do is I'll go to this Gmail, and in Gmail I'll go to this Google Calendar. Okay, so here within this Google Calendar, if you click on this question mark, you have help menu. So मैं ये पूछ रहा हूँ कि अगर कुछ कैलेंडर इवेंट्स इंपोर्ट करना है तो कैसे इंपोर्ट करना है, जैसे कि मेरे पास एक्सेल है या कहाँ से नोटपैड है, how I have to import, that question I am asking the Gmail. So I'll say import events into calendar. Okay. So it has given this. So what I'll do is, let's say I want to import from the computer itself. Okay, तो मैं क्या करूँगा, ये पूरा जो help इसने दिया है, help menu, क्योंकि इसमें अगर import करना है, आपको तो ये MMDD format, month and DD, because Google का अलग ही format है. You have to see that the date is created as MMDD, you have to give it in double quotes, you have to give the time in so and so format, which is very difficult for us to create. So what I'm doing is, I'll copy this entire help menu, जो भी है, वो पूरा help menu copy करके ChatGPT के पास जाऊँगा, ओके, और उसको ये हेल्प मेनू पेस्ट करूँगा. पेस्ट करके एक प्रॉम्प्ट मैंने बनाना है. आई जस्ट शो यू. आई एम सेइंग दैट आई एम प्रिपेयरिंग अ गूगल कैलेंडर यूजिंग so and so, and this is what we have copied earlier also, the same thing what we have pasted in Google. This is there in the file which I am showing. You can import and all that. At the end, I'll say आपको सर्च करके मुझे एक गूगल कैलेंडर कंप्लेंट्स कैलेंडर बनाना है. उसमें आपको सर्च करके कौन सा रिटर्न्स कौन से डेट पे फाइल करना है, who are all have to file in what dates, that is the prompt what I am giving. I am saying that I will not give that prompt saying that give me 12 months, क्योंकि GPT ऐसा है कि easily it might go into hallucination. Hallucination means भटक जाता है कभी कभी. तो इसके लिए आप क्या करना है, पहले एक महीने के लिए देने के लिए बोल दीजिए, give it for only April. आप रिव्यू कीजिए, perfect है, then you say okay, give me for another quarter or 12 months. So initially that's how you control the AI. So what I'll do is I'll just copy this, and I'm saying again whatever I'm displaying, everything is shared in the Google Drive, which I'll be sharing through QR code scan. So I'm going there, I'm pasting that and run it. So it start doing research, going through the websites, going through various information, and start compiling the calendars for the month of April. Okay, so what it says, it has given this saying that GSTR 7, 10th of April, 10th of April, 11th of April, 13th of April, something like that. Let's assume that it is correct. I'm not reviewing for the sake of time saving. I'll say, okay, how about generating for the entire period or financial year 25-26 and provide in CSV download format. तो उसको पूरा बना के मुझे सिर्फ डाउनलोड के लिए पूछ रहा हूँ ताकि मैं गूगल कैलेंडर में अपलोड कर सकूँ. And all this within matter of few seconds. We are not even जैसे कि इसने डाउनलोड दे दिया है. We'll see what is there in the file. We'll open this particular file. So almost like 60 rows का दिया है, and this is in MMDD format. Okay, that's where. So it is also given that what is the due date for the month of April, ISD return, monthly return, 1, 6, 3B, 7, 8. So now my job is pretty simple. Let's say I'll just go to Google Calendar, जो पहले आपने open किया है. I'll click on these settings. Click on these settings. ये इधर import export है. आप इधर select करेंगे वो फाइल को और सिर्फ import दबाएंगे. तो जो भी events उसने create किया है, everything got uploaded in your calendar. If Google is synced to your mobile, you will get an alert in your mobile also. आज इसका due date है. आप ये भी बोल सकते हैं कि आप due date से एक दिन पहले आप alert create करो और 30 minutes पहले जो भी है. Now you can share this CSV file to client also. सर आपको ये ऐसा step 1, step 2, step 3 import करना है ताकि आपको alert भी create हो सके.
So we generally maintain the diary for the courts.
Yes.
So whether that can also be in the CSV?
Yeah, provided you give the sources from where it has to pick up. जैसे कि cause notices जो publish होते.
Do we convert into the PDF?
Yeah.
And then
yeah, even otherwise. जैसे कि if you go to this e-courts and all, there will be cause list provided or show cause, whatever it may be. Then you give the source of
the different sites.
Yeah.
So that's why we have to maintain the diary.
Yeah, see what you can do is, just to share my idea, you can provide all the links into Google Notebook so that it will compile all the information in one place. You generate a report, that report you give it to ChatGPT to provide a CSV file, if in case you don't want to do manually. You just need to include the couple of extra steps, but yes, it can be doable. can be doable.
But if I have the in my computer, that cannot be converted into CVS and.
You can do, probably just need to share that particular PDF because GPT are equipped with any kind of Python code, libraries which can do whatever job you want. Parsing or extracting into Excel, CSV file, Word file. You just need to give, that's it. You don't need to, probably do anything extra. As long as you are not worried about, let's say, confidentiality, you have masked the names and all, then you pretty much can share, it will do the job for you. It will convert that PDF into CSV file and you can upload it to Google Calendar.
And it will be shoot up in the date wise.
Pardon me?
In the calendar wise.
No, it will do for the entire year. You just share your calendar as, आपको और एक ये भी देता हूँ उसका, let's say you have a diary in a written format.
Yes.
Okay, you scribbled it. Yes. That you take a picture and you upload it to GPT to make it a structured CSV, it will do. आप डॉक्टर का प्रिस्क्रिप्शन अगर उसको देंगे तो पक्का रीड करके देगा जो usually we can't do. तो वो कर सकता है तो अपना राइटिंग तो comparatively better है. Okay, so coming back to our cases, so that's why fifth case. And this is one more important thing. This, of course, as I said, this is pretty much there in the Google Drive. एक ये प्रॉब्लम होता है कि कोई इन्फॉर्मेशन मैं अगर शेयर करता हूँ GPT, आई एम वरीड अबाउट द कॉन्फिडेंशियलिटी. जैसे कि it has the name, of course, dummy names what I put. It has the name, it has date, email ID, which I don't want to share it to GPT. So I want to mask it. We call it as redaction. Okay. तो अगर इसको redact करना है तो आप क्या कर सकते हो, जैसे कि इसको मैंने chat GPT को, I just created a new chart. I've shared this with GPT. Okay. And I'm asking identify the personal and sensitive, or you can say confidential. Sensitive to financial health ये होगा. Information from this record. Dummy file देके पहले जो भी dummy file दीजिए उनको. आपके पास तो Computax, Genius जैसे सॉफ्टवेयर्स होंगे, उसमें एक dummy file create कीजिए, उससे PDF generate करके उसको दे दीजिए, identifying. Why we are doing this is to make it understand what is the form I am given, how it is going to identify. So it has identified name and all. Okay. Then I'll request provide me a code. Of course, this is a programming kind of thing which you, if you are not able to do, probably you can have your own staff और आपके relatives में कोई तो engineer होगा. खाली टाइम पे उनको बोले कि ये वाला requirement है using ChatGPT, whatever it may be, how to do. So it's very simple. I mean, just to share, in our office, around 35-40 students out of 80 articles, they started automating by generating their own tools. जैसे कि कुछ review करना है, they have created a tool which will do review based on the particular code which they have created in their own system. They are not uploading elsewhere. थोड़ा टाइम लगेगा आपको. अगर चार्टर्ड अकाउंटेंट्स है उनको तो AICA करके सर्टिफिकेशन है, अगर वो अटेंड करेंगे तो आपको ट्रेनिंग हो जाएगी. अगर नहीं है तो भी यूट्यूब चैनल्स में देखिए, बिकॉज यू आर नॉट पुटिंग एनीथिंग ऑन कोडिंग, यू आर टेकिंग द हेल्प ऑफ ChatGPT एंड यू हैव टू बी पेशेंट इनफ टिल यू गेट ए राइट काइंड ऑफ कॉम्बिनेशन. दैट्स ओनली थिंग. तो मैं इसको ये बोलूँगा कि अगर इफ आई वांट टू मास्क और रिडैक्ट द above information and generate new PDF, what script is that required? अगर ये बोलेंगे तो आपको स्क्रिप्ट देगा. I mean, how to generate and all. I'll probably another session workshop kind of thing if in case we meet. Yeah, conclude. Yeah, sure. So I'll just show you one particular. जैसे कि आपके पास एक ही PDF है, मैंने ये कोड क्रिएट किया है, जैसे कि आपको बता रहा था. दिस वाज क्रिएटेड ऑन 4 नवंबर. मैं इसको खाली क्लिक करूँगा, कुछ नहीं करूँगा. ये कोड क्या करेगा, जो ITR में जो इन्फॉर्मेशन है आइडेंटिफाई करके उसको मास्क करके नया फाइल क्रिएट कर देगा. तो इस हैज क्रिएटेड नया फाइल जिसने मास्क कर दिया है. So everything can be done. It's only that how patient you are. Or let me just quickly move around, move ahead. Finally, I was saying about tools, various tools. एक आपके पास इतने सारे चलान्स है, आपको एक्सट्रैक्ट करना है. ओके, क्या कौन से नाम पे भरा है, कितना अमाउंट भरा है, इसके लिए ChatGPT के हेल्प से ये कोड जनरेट किया है जो अभी गूगल फोल्डर में अवेलेबल है. मैं खाली ब्राउज करूँगा. वो फोल्डर को ब्राउज करूँगा और जो चलान्स है वो पूरा एकदम इसको इंपोर्ट करूँगा, खाली प्रोसेस दबाऊँगा. प्रोसेस दबाते ही it will extract all that information from the challans in a tabular format. Okay, as a sample I've shared this code also, you can download in mobile also, you can start using it. And just last couple of minutes and I'll conclude. Okay, trial balance scrutiny and all, we can, before I conclude, let me share the QR code so that you can take a picture of this. बाद में इसको स्कैन करेंगे तो आपको गूगल ड्राइव लेके जाएगा, जो भी केसेस है मैंने जो बताया आपको डाउनलोड करने के लिए, उसमें प्रॉम्प्ट्स भी है, यू कैन डाउनलोड दोस प्रॉम्प्ट्स आल्सो. So my only request is don't avoid, because regulators have adopted, your clients are going to adopt, your children are going to adopt, your students are going to adopt. So instead of avoiding, try to identify ways how I can probably how I can use it in my own way. Okay, you start trying to do that, you will find kind of value addition, because we don't have quality resources available now. We don't have smart, passionate students now available. We have smart brains but not passionate enough. So that is where these kind of tools will help you bridge that particular gap. Okay, and so considering the time, I'll just conclude with this thank you note, and I've included this volunteers of Vikas Bharat after coming over here, because I believe tax professionals are the actual volunteers of Vikas Bharat if in case it has to be achieved by 2047, because we are the direct contributors to nation in various forms. So I believe you people, especially the Tax Professional Association, are doing great jobs in coming out and coming up with this kind of value addition to the country. Thank you all. Thank you very much for your patient listening. Thank you. No. It has to be properly structured prompt. Prompt should be something where I give a context, I give objective, I give subjective, I give preface. It has to be properly structured. That's where prompt engineering they are paid huge salaries, like 2.5 to 3 lakh per month kind of salaries, for the reason that they know how to structure a prompt. Even if we give, it's just in English for it. It may not, it can control maybe 5%, 10%. Irrespective of whatever. Yeah. Yeah, it will not come, because see, we are income tax, it's our domain, GST is our domain, software people can't do. So prompt engineering is something domain related to AI or machine learning people. Only those people, they know how to compose the token, how to see that proximity tokens are landed. So that's how it is specialization.
Thank you, sir. Thank you. So first of all, I would like to thank all the participants here. Sunday का दिन, दोपहर का टाइम, खाना खाने के बाद अगर हम लोग सब यहाँ पे एक ऐसा टॉपिक पे डिस्कशन कर रहे हैं which is something different from our day-to-day life, then we all deserve a round of applause. A big round of applause for everyone sitting out here.
Thank you.
And to sir for wonderfully explaining the different concepts of generative AI, artificial intelligence, data privacy के बारे में सर ने बताया, different tools बताए, OpenAI, ChatGPT, Claude, नोटबुक LM, AI ब्राउजर कॉमेट के बारे में सर ने बताया, कंप्लायंस कैलेंडर गूगल से कैसे. सो इट्स लाइक द मोर वी ट्राई टू डू R&D विथ रिस्पेक्ट टू डिफरेंट टूल्स, द मोर विल बी एबल टू अचीव effectiveness and efficiency in our professional life. So thank you, sir, for your wonderful deliberation. I would request Prasanto sir to please come and offer the formal vote of thanks.
First of all, before proceeding vote of thanks, all of you to Jai Sri Jagannath. Today's session chair, learning chartered accountant Sam has given brief introduction about AI and role of AI. Thank you, dear Sam, for your valuable insight as a session chair. Thank you, learned speaker CA, Vijay Srinivas ji, sharing your valuable insights and expertise on AI. Your presentation was informative, engaging, and thought-provoking. We appreciate the time you took to prepare and deliver such a fantastic session, sir. To everyone who attended, thank you for your active participation and enthusiasm. I hope you found the session useful and enjoyable. Let's keep exploring the possibilities of AI and look forward to more such sessions in the future. Thank you again, learned speaker, CA Vijay Srinivas ji, and to everyone who made today's AI session possible. Thank you, sir.
Sure. Now we are coming to the end of this Golden Jubilee inaugural ceremony. I would request Sir Vivekanand Mohanty, Senior Advocate, Immediate Past Chairman, to please come up and take the dais. I will request my own zone chairman, Sri Shantanu Chaudhary, to please come up and take the dais. I would request my elder brother, my fellow colleague, Senior, Vice President, AIFTP, Advocate Kumar from Hyderabad, to please come up on the dais. We have among ourselves from the city of Kashi, Sri Arvindji Shukla. Sir, please come up on the dais. नाम नहीं है. Validatory. कौन? Our future journal chairman. नहीं, you want to do that. और एक कौन किसको? हो गया तो? एक और नहीं, इससे और चाहिए ना. दिव्यपति गया क्या? कहाँ है? बाहर है, बुला. I would request Senior Advocate Sri Divipati sir, I think he's having tea, to please join us. As we come to the end of the... नहीं और नहीं चाहिए? नहीं. As we come to the end of the inaugural session of Golden Jubilee 2025, I, the conference chairman, thank you everyone, all the delegates who have come through nook and corner of India. This conference is only a success with your support and active participation. With this, this conference, it has taken a lot of hard work by the organizing team. Let us all appreciate Sir Divipati sir is here, Senior Advocate, Patna High Court. Sir, please grace the dais. This conference has been a success only because of the hard work of the organizing team who has worked day and night in spite of the busy tax audit schedule, Deepavali and Durga Puja. They have taken the time out to make this conference a success. It is our time to show gratitude to this working committee. I will give announcing the name one by one. Please come. The names are not taken in any order. If I miss out any name also, my apology. All have worked very hard. Thank you. Shri Rajesh Kumar Mishra, convener of the conference. I will request Mr. Kumar to hand over it. Sri Sandeep Pal. He has worked very hard to make new members and bring in more delegates. Our tech team, AI team, and the youngest member who has joined AIFTP and worked day and night in spite of medical issues and everything, Shri Shyam Agarwal. I will request Arvind Bhai to give it.
It's really my pleasure to hand it over. I've learned a lot from you.
Sham, ye de do, Arvind Bhai ko. Shri Ankit Botra, again a young chartered accountant who has worked hard for the souvenir, called up everyone for the articles. Thank you. Shri Padmanand Dave, who has taken time out after the extensive trekking, वो outstanding support था. ये conference है. ये तो हो गया. राजीव कुमार दे दो. Shri Jeevan Kumar Das. If he's not there, I'll request anyone from Orissa if they can take it. Shri Rajiv Kumar. Anyone from Patna? Shri Purna Chand Hota. Nahin. Anyone from Orissa can come and take it. Shri Pradeep Kumar Agarwal, CA, who in spite of the tax audit limitation, has organized all the finances and managed the conference very well. राजीव कुमार बोल दिया ना? राजीव का नाम बोला? बताओ. Shri Ashish Prasad from Patna. Now the most important person, without whom the conference cannot happen, because he is the person who signs all the checks and payments. My zone treasurer, Bhaskar Sinha Roy. Shri Akhilesh Kumar from Patna. Smith, Akhilesh ka le le. वो किसका? वो बात इतना ही है. Now, from whom I have learned the art of discipline, how to conduct good technical sessions, a very senior advocate, Shri Vivekanand Mohanty. I will request Divipati sir to please hand over. Our future president from Eastern Zone. हो गया सबका? Hey. Our next chairman, under whom we have to work very hard, who is a popular figure throughout India, Shri Smith Saurav. Shri Sudeep Nopani, Zone Secretary, popularly known as Mamaji. all the workers. The man behind the grand setup, the man who has made all the pickup and drops possible without fail, even if his team has to wait for hours at the airport as the flights were rescheduled because of the malfunctioning of ATC in Delhi. This setup, this hotel venue, the real man of the show, Sunil Mishra, VC Communication. Please give a standing ovation to him. I would request his team also to come up. They are the real heroes of this event. This team has not slept for last 3 days, and they are staying in nearby hotels only to make this event a success. It's all. तेरे को अच्छा छोड़ दे The backbone of this conference, without whom I as a conference chairman could never imagine to have a conference. From the last 3 conferences, my backbone, my ultimate support, the person whom I can look at the last mile, my conference secretary, Girdhar Dhelia. Please welcome him with a round of applause. I request Mr. Kumar and Mr. Mohanty to give it. He is the man who has taken care of everything. Applause should be very loud.
Thank you, Vivek Bhai. And we all, I believe, give the standing ovation after presenting the award. But I request all of you to favor me by standing by now, because now we are talking about the person who has curated, concepted, and make this conference, and the entire 2-day, 48 hours we are looking at. But the past 48 days and the 48 months we have not seen, and the person behind it, the backbone of the zone, Mr. Vivek Agarwal. A huge round of applause. I'll request all on the stage, Vivekanand Monty Saab, Kumar Saab, the zone chairman, D.B. Pati Saab, and obviously the Shukla Saab to join and to give the moment of the conference. This is not an award simpliciter. This is the entire conference. The success of the conference speaks about this. Thank you so much. Thank you all. Thank you all. And that's the closure of the conference. National anthem. एक बार और क्लोजर में हम लोग करते हैं, कल भी किए थे. We have high tea and tea after this national anthem. So I request all of you to be stand up for the national anthem, and thereafter we will enjoy the high tea and conclude the conference. Thank you.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे